Court will be back in session and we'll bring in the jury at this
Your Honor,
time.
if
Yes.
I may,
Yes.
prior to the bringing in of the jury, I'd like to move to admit an exhibit. And if I may present that to the court,
Uh,
and I've
Okay.
given a copy to counsel.
Okay. Is there any objection?
No, Your Honor.
And
Oh, I should have it marked then.
yes.
Subject to the previous objection raised in a motion in limine. This is the record of the careless driving ticket. The court has ruled on that. I would just reiterate that objection, but understanding the court's ruling, we don't object at this point.
Okay, thank you. And this will be marked as
6, right?
plaintiff's exhibit number 6 will be received in evidence.
I'll be incorporating this in testimony later today, I think. And for benefit of court counsel, I think I'll be done with the case in chief today.
Okay,
Thank
thank
you,
you.
And we're prepared to proceed.
All right, anything further before we bring in the jury?
No, Your Honor.
Okay, thank you. You may bring in the jury at this time. Good morning, everyone. Please be seated. Mr. Steinoff, you may call your next witness.
People call Special Sergeant Berlin.
Please come forward, sir. Please raise your right hand. Do you solemnly swear that the testimony you're about to give in this case will be the truth, the whole truth, and nothing but the truth?
I do.
Please be seated. You may proceed when you're ready, Mr. Stein.
Thank you, Judge. Good morning, sir. Could you state your name and spell your last for the record?
Yes, Daniel Berlin III, last is V as in Victor, ERLIN.
And what do you do, sir?
I'm the crash reconstructionist for the Michigan State Police for the 8th District, that's the whole UP.
Okay. And what rank would be assigned to you for that role?
I'm a specialist sergeant.
Okay. Can I call you Sergeant Berlin?
Sure.
And how long have you been doing this work?
For the crash reconstruction, about 3 years.
What qualifies you to do that work?
It's a specialist position in our department. That's the rank specialist sergeant. So we go to we graduate from the State Police Academy. From there on forth, we have additional training in crash investigation, crash reconstruction. Once I got this position, I had to take various crash reconstruction courses throughout the whole US and Michigan. After those series of courses, I had to obtain accreditation through the Accreditation Commission of Traffic Accident Reconstruction, otherwise known as ACTAR, as similar to the bar or the medical exam school, but for crash reconstruction. So it is a all-day test. The test is in the morning is a theory portion. In the afternoon is a practical application portion where we're given details about a crash, and we have to determine speeds, the way the vehicles hit, etc. After full accreditation, I was promoted to sergeant and then take various courses throughout crash reconstruction from there.
So you passed the test?
Yes, sir.
Okay, excellent. And you carry the certification that's accompanied with that?
It's an accreditation, not a certification.
So, how many crashes have you investigated?
To date, about 500 of them. I don't keep an exact number, but I know I've done over 500.
Any of them involve serious injury?
About 100 of those 500 are fatal or serious injury crashes.
I'm gonna show you a document here that I want to call people 7. And if I may approach the witness, Your Honor,
You may.
could you tell the jury what this is, or tell the court rather?
Sure. This is my CV. I don't want to pronounce it's curriculum vitae, I think the proper pronunciation is. But it is a list of all my trainings, basically through law enforcement and crash reconstruction.
Can I approach again, Your Honor?
You may.
And I would move to admit number 7.
Any objection to people's number 7?
No objection.
People's number 7 will be received into evidence.
And I'm not going to publish to the jury at this time. I'd like to publish to the court with permission.
You may. Thank you.
You ever testified before?
Yes, sir.
Okay, how many times?
As an expert, 3 times.
What about as a non-expert?
I do not know. At that point in time, I wasn't keeping track of how many I did testify.
How long have you been working for MSP?
About 8 years now.
Okay. I'm gonna move to qualify Special Sergeant Berlin as an expert in crash reconstruction.
No objection.
Okay, thank you. This witness shall be deemed an expert witness in the field of crash reconstruction.
Are you familiar with the case of People versus Houghton?
Yes.
How are you familiar?
Initially, I came to know about the crash, initially through crash reconstruction. I do safety and speed limits throughout the Upper Peninsula with MDOT. Since this crash happened on a state trunk line road, I do a little bit of safety analysis with MDOT. So that's how initially I was made aware of the case, shortly days after this originally happened. A few weeks ago, I know you had contacted me about this case and forwarded me some data.
Okay. So did you do any kind of analysis? In that regard?
Yes.
All right, what did you analyze?
The Jeep's event data recorder had been imaged, and you had forwarded me that data that was extracted out of the event data recorder.
Okay. And without taking all morning, how did you analyze the data?
So we're able to basically plug into either the vehicle or that event data recorder. That data comes out and we have to match that data to the crash in question. So I look at terms of things and key cycles, how many times the vehicle turned its key on and off, whether or not that matched the key cycles at the time of the crash to the time the download happened. I also look at things like the odometer. I also look at things like the change in velocity, we call it delta V, the change in speed, the principal direction of force, i.e. where the crash happened on the vehicle, where the force came in. And all of that data suggested that the data in that report matched this crash event in question.
Okay. I've been saying in general, when I talk about EDR, black box. Is that fair?
I would say it is. They used to be silver, but now they're black.
So like in an airplane, we have a black box, you see it on TV when there's an airplane crash.
Right.
Is that the same kind of thing?
Similar, but those are orange. When I flew helicopters, they were
Alright.
black. But yeah, so it's the same type of thing. It's usually they're recording on some type of buffer, and when an event happens, there might be a recording trigger that happens, but same type of thing.
Okay. So based on were you able to match the data in the EDR report with the crash in question?
Yes.
Okay. Based on your analysis of that data, were you able to determine, say, how fast the vehicle was moving at the time of the crash?
Yes.
How fast?
Up to the point of impact, the vehicle was in a speed range of anywhere from 69 to 72 miles an hour.
Okay. You know the speed limit on that stretch of roadway?
Yes.
What is it?
65 miles an hour.
I just want to cover something here. The speed limits in Michigan have gone somewhat haywire in the last few years. Just to be clear, November 2nd, 2019, what was the speed limit on that stretch of roadway?
I would have to double check, but the speed limits that got changed from 55 to 65 were all in 2017. So
Thank you.
65 at the time of the crash.
And does the EDR recorder, the EDR thing, measure how much pressure is being placed on the accelerator at any given time?
For this particular vehicle, yes.
Okay, and for the record, what kind of vehicle are we talking about here?
It is a 2017 Jeep Cherokee.
Okay, so in the time preceding the crash, let's say 5 seconds prior to the crash, how much pressure was the defendant putting on the accelerator?
It ranged at the beginning. It was about 40-ish%, which is about halfway, indicating the brake, or excuse me, the accelerator was being depressed about halfway. Up until about the point of the crash, it appeared to be let up to about 25%. In the second or so prior to the crash, there was basically some throttling back and forth. So it went to 0, then up to like 6 and 12%, then back to 0.
How do you explain that? Are you able to explain?
It sort of matches the terrain there.
Okay.
So it was an uphill ascending curve. So I would expect a person to be a little bit more heavier on the accelerator going up that hill, and possibly letting off the accelerator to maintain the speed as the ground levels out.
You live in Marquette, don't you?
Yes,
Okay. You came down that hill on the way here, is that right?
yes.
Does the hill, we've covered this before, but could you explain the roadway at that juncture, at the point of the crash?
So if you're going westbound, I don't know if you're familiar with the Deer Lake area, but it's just a little bit past that towards the west. The westbound lane becomes a 2-lane passing lane. The eastbound lane still is a single lane. So the dual lanes go up, slight curve to the left. It sort of levels out for a little bit. When I say levels out, it's not perfect level. Just the terrain sort of shallows out, and then it goes up and to the left a little bit more again, and then that curve actually straightens out. The point where the curve straightens out, that's where the 2-lane passing lane again becomes a single lane.
At the point of you said slight curve. At the point of the crash, how far could an individual see in front of them until the roadway curves away or levels out?
Throughout that whole curve, the least amount of sight distance was about 1,300 feet.
Okay,
So that about a quarter of a mile.
okay, that's the least amount.
Right.
I want to go back to this accelerated pressure thing. Does the speed of the vehicle on the ADR recorder correspond to your assessment of the pressure on the accelerator?
Yes.
5 seconds prior to the crash, what was the speed of the vehicle?
I would have to look, but it was probably 71, 72-ish.
I don't want you to guess.
Right.
I'm gonna, would reviewing the report help refresh your memory?
Yes.
Okay, I want you to review the report here on the speeds that, up to the point of, without reading the report. Let me know when you're ready.
Okay.
Okay, can I approach your arm? I'm sorry.
You may.
Thank you. 5 seconds prior to the crash, how fast was the defendant going?
71 miles an hour.
Okay. What about 4 seconds?
Was still 71,
3,
72.
2,
That was 72 as well.
1.
I would have to, it's a 70.
Can I approach your arm?
You may.
Record should show us refreshing the same document.
Okay, 1 second prior to the crash.
70.
So from 5 seconds to 3 seconds, the defendant actually sped up, is that right?
Yeah.
Okay. Five seconds at 70 miles an hour. How far? It's math.
So about 70 miles an hour is about 100 feet per second.
We're kind of 500 feet. Is that
Correct.
right? How long is a football field? How many feet?
Well, from end zone to end zone is 300 feet or 100 yards.
Like, is it fair to say a football field and a half? Or
A
close to
little
two-
bit more. I would
Close to
say.
2 football fields? When did the defendant apply the brake? Were you able to tell that from the DVR?
I don't know.
Okay, why not?
Um,
Let me ask, and let me withdraw that, and I'm gonna back up. Does the EDR measure brake pressure?
this particular one, no.
Okay. Does it measure anything corresponding to brake?
Yes.
What?
It measures what's called the brake status, brake symbol status. There's a lot of terminology, but the basic thing it's measuring is whether or not the brake lights were activated. And how that's activated is the brake pedal. You may have all seen it and heard it in your vehicles before. When you slightly press on the brake, there's a little switch and you can sometimes hear it. So it's just a slight forward movement of the brake pedal, just enough to activate that switch and power the circuitry to illuminate the brake pedals, the brake lights.
So why don't you know when the defendant applied the brake, or if the defendant applied the brake?
With this particular crash, the circuitry was activated only 1/10 of a second prior to impact. Sometimes I've seen with that close of a time to impact, the actual crash forces riding down are sending that brake pedal forward and illuminating that light, even though there's nobody on the brake pedal. So that's why I don't know if the defendant was actually physically on the brakes or if the crash forces were actually moving that forward just enough to illuminate the circuitry.
Did the defendant have their cruise control on? Were you able to tell that?
Two-part question.
Okay, part one, were you able to tell whether the defendant had the cruise control on?
Yes,
Did the defendant have the cruise control?
no,
Okay. Does the EDR record steering activity?
yes, this one does.
Could you describe what the EDR showed as far as steering activity is concerned in this particular crash?
This one was very minimal, up until the few tenths of a second up until impact. So -1, -2 degrees, which is basically what any normal person would have traversing this roadway, up until, again, the point of the impact or the time of the impact. There was a very, very slight turnage, but only, I believe it was 7 to 9 degrees. So nothing drastic.
Would you say that the 7 to 9 degrees is consistent with evasive action?
No.
Okay. So like, it's not like, could you show, what is 7 to 9 degrees?
Right, 7 to 9 degrees, again, is, well, very small amount. If straight up and down with the steering wheel is 0, all the way to the left is 90 degrees, all the way down is 180. So 7 to 9 degrees, beginning maybe a part of an evasive action, but nothing like I just saw doom in the windshield and now I'm turning it.
Okay.
And the ones I've seen before, there's no question whether or not the evasive action is going on. So,
I see. Let's talk a little bit about lanes, and where I'm gonna show you some pictures here. Did you review photographs that correspond with this accident?
yeah,
May I approach the witness?
You may.
I'm gonna show you what we call People's Proposed Exhibit 1. Do these look familiar to you?
yeah.
Is that 1A, B, and C?
Yes, I'm sorry, Your Honor, 1, A, B, and C. And what are they?
This is the roadway in the area of the crash site.
Move to amendment number 1, Your Honor.
Any objection?
Yes, may I water the witness?
You may.
Sergeant Berlin, did you take those pictures?
No,
Do you know who took them?
no.
How are you certain that those pictures depict the roadway, the site of the accident in question?
Because I've been to that crash area before. I know where the crash site is generally from reading the crash report. So this looks exactly like the crash, the site the crash would have happened in the general area.
Okay, so you're speculating that these are pictures taken of that general area based on the report?
What report? The UD10 crash report?
Yeah, I mean, you referenced having, that the foundation of your knowing that these pictures were of that area was a report. So that's a
Yes.
report I'm referencing.
Yes.
Okay, so this is the traffic crash report?
Yes.
What specifically in the report leads you to believe that these pictures depict that particular site?
The crash report stated that the crash happened on M28, 1.5 miles west of Shelter Bay Road. And with just me going through this area several times, I recognize that area from these pictures.
Okay, and are you certain that those pictures are taken of the actual site of the accident?
No. So this is the general area, whether or not this was within plus or minus 100 feet of the crash. No.
All that. And it looks like, looking at those pictures, it's kind of green grass in the area, bright sunny day. Those were not taken at the scene at the time of the accident, correct? As far as you know?
Crash was in November. I doubt this represents November.
Okay, and you don't know who took those pictures?
No.
At this point, I think the photos are irrelevant. We don't have them depicting a particular site of the accident and also don't have foundation for their admission.
Any
I
response?
agree. I'll
Okay,
try again later.
all
Can I
right.
approach the witness, Your Honor?
Yes, you may.
Ladies, you did review photographs of the scene, is that right?
Yes.
Okay. And did you use those photographs to make conclusions?
Yes.
Okay. First, I want to ask you a question as in your experience as a crash reconstructionist. Do different people have different interpretations of what the shoulder of the road is?
Possibly.
Okay. So, is it fair to say that some people say shoulder of the road and correspond that with side of the road?
It could, yes.
Okay. And would they say that irrespective of where the fog line is?
Objection, I'm sorry, this is speculation. This is calling for this witness to speculate about what some people might say.
I'm asking for the witness's specific experience as a crash investigator.
All right. I'll overrule the objection on that basis.
Can you repeat the question, please?
Would some people say, in your experience as a crash investigator, do some people say, when they talk about shoulder of the road, side of the road, are they saying those words irrespective of the fog line, meaning they're not taking into account where the fog line is when they're saying that?
It depends on their personal recollection of it. So, throughout my crash investigation, I've had witnesses and people tell me something that was totally wrong to what a 4K video was showing, but whatever they recollected in their mind was what they remembered.
Okay.
So,
were you able to make a determination on where the vehicles were at the time of the crash?
yes.
Okay. I have a whiteboard right here. With the court's permission, I'd ask Special Sergeant Berlin to draw a diagram.
Okay, granted.
I want to make sure of what he can see.
I'd invite council to come over if that's necessary, or we can draw it out and then look at it, but the important people
Okay.
are here. Yeah.
Basically, here is the westbound lane of M28. So here's the dual lanes, the dual yellow center line, you have your white dashed line, you have your fog line with your associated shoulder. Crash pictures that I saw had a fluid trail that was, the majority of that fluid trail was in the center of that right-hand lane that went off towards the shoulder of the roadway.
What's the squiggly line?
This line here?
Yeah.
That's the grass and gravel. So it's
Okay.
partly gravel after the edge of the pavement
Okay,
and then goes into grass.
so did you come to an opinion on where the white Mercedes was in the crash?
Yes.
Did you indicate that?
So the overwhelming majority, again, this is a area of impact. We don't really talk about points of impact. We talk about area. The area within a couple feet. So the majority of that vehicle was likely, when those two vehicles hit, was likely, this is not to scale, this is I'm not an artiste, but this is what the scene evidence suggested. right?
Okay. Now, is it possible, based on the scene evidence, that that Mercedes was partially in the lane, partially on the shoulder?
Yes.
Okay. And as for the people in front of you can resume your seat, sir, thank you. As for the people in front of that white Mercedes, where were they located? Are you able to determine that?
For certain, no. I did see a gouge in the middle of the lane, which I thought could have been a tub, which would suggest that he would also be in the lane, but
Would that be speculating?
that would be just off looking after 500 crashes after evidence, what it would be, so.
Is the EDR data consistent with the rendition of events given by the defendant at the scene?
Yes.
Okay. No more questions?
Cross-examination, Ms. Henderson.
Sergeant Berlin, you and I have not met previously, is that right?
Not that I know of.
Yeah, I don't think so. You did speak to my associate attorney, Victoria Hero, a couple weeks ago in my office, though, correct?
Yes,
Okay, and you were able to kind of give your opinion at that point.
yes.
You were cooperative with her questions.
As far as I know.
Yeah. Yeah, that's the report I got, so that's good. I want to ask you first about the speed question. The speed of the Jeep Grand Cherokee.
Okay.
You said the general range of speed was somewhere between 69 to 72 miles an hour. Do I have that correct?
Mhm. Yes.
Yes. And the posted speed limit was definitely 65 miles an hour in that area.
Without looking at the traffic control order, 99.999 repeating percent that the
Yeah.
speed limit was 65.
With the crash having occurred in 2019 and those major changes taking place in 2017, 65 was the,
Yes.
no, then that's not a disputed fact at this point.
Okay.
The speed of 69 to 72 in a 65 mile an hour zone is within normal limits, is it not?
Can you say that one more time, sir?
Yeah. Traffic traveling at between 69 and 72 in a 65 mile an hour zone, that is within normal limits.
I am going to object here, Your Honor. I think that the question is overly broad and speculative. There's no definition of what normal limits are.
Well, this is cross-examination, so overruled.
As far as no, what do you mean by no?
Well, I mean, you would ordinarily expect traffic to travel a little bit above the posted speed limit. That's fairly normal driving behavior, is it not?
When we do the speed limits, part of how we set the speed limits is people driving over the posted speed. So
Right.
that would be a normal occurrence, if that's what you allow me to say is normal.
Well, and I think I hear you agreeing with me. I mean, would you say that it is, that a prudent driver does not necessarily stick strictly to the posted speed limit? It's not necessarily, that's not necessarily a behavior that is necessary to be a prudent driver.
I would agree with that.
And 4 to 7 miles an hour over the speed limit is within general traffic norms.
Yes.
Driving 4 to 7 miles an hour over the posted speed limit is often safer than driving below the posted speed limit. Would you agree with me?
Yes.
And it's definitely safer than driving 60 miles an hour under the posted speed limit in a 65-mile-an-hour zone.
Yes.
The fact that the Jeep Grand Cherokee was traveling 70 to 72 miles an hour in a 65-mile-an-hour zone, that does not alone establish careless driving. Would you agree?
I would agree with that.
Now I want to talk about the construction of the roadway in the area of the crash. You were asked by Mr. Steinhoff to describe the roadway, and it's pretty much undisputed. It's an uphill curve. Would you agree?
Yes.
Curve to the left.
Yes.
You reviewed only EDR evidence from Ms. Houghton's vehicle. Is that correct?
Yes.
Not from any of the other vehicles involved in the crash.
Correct.
All right. And the EDR for Ms. Houghton's vehicle contains data not only from the point of impact, but also from some time before. Is that correct?
Yes.
Time before driving on the express or on the highway?
Yes, yes.
The EDR didn't show any evidence in the seconds before this accident where Ms. Houghton appeared to have left.
Correct.
So she was maintaining her lane driving up this uphill curve before the crash, correct?
All the evidence would suggest that, yes.
She didn't drift off the road because she was absorbed with something she was doing in the car.
I don't have any evidence to suggest that would be the case, no.
And do you agree with me that it's normal, prudent driving behavior to sometimes divide your attention between something happening within the cabin of the vehicle and the roadway that you're attending to?
Yes.
Not uncommon for people to adjust their radios as they drive.
Not uncommon, correct.
That is not in itself careless.
No.
Did your reconstruction analysis reveal any evidence of any markings on the Mercedes or the truck, like a sign, strobe light, bar light, any kind of equipment that would alert traffic coming from behind to the fact that there was something unusual ahead?
With the information I have, I cannot make that determination.
Okay, you reviewed some photos as part of your workup in this case, is that correct?
Yes, just to not refresh, but kind of familiarize myself with what a tub push is. That's a tub push.
Yeah.
So I had to look up what exactly it was.
Okay, and did the prosecution share with you photographs that the Alger County Sheriff's Department took of this crash scene?
No.
Okay, so you didn't, as part of your analysis, look at any of the photographic evidence. Well, you did though, correct?
Yes.
Talking about the placement of the fluid in the road.
Yes.
Your Honor, do you have the people's exhibits of photos?
Yes, two,
Thank you. This is, if I may approach,
you may.
I'm gonna show you this exhibit that's been marked and admitted. This people's exhibit number 2. It's a series of photographs of the crash scene. And you can take your time looking at those.
Okay.
You've now reviewed those photographs. Have you seen those before at
Yes.
some point? And having reviewed those photographs to refresh your memory, is there any evidence in those photographs that there was any kind of bar light, strobe light, signage, anything on the vehicles themselves that would indicate that there was a charity tub push happening?
Can you repeat that one more time?
Yeah. Do you see any evidence that there was special lighting, like a strobe light or a bar light on the top of the Mercedes or the truck to indicate something weird's happening up ahead?
No, I can't see that from these pictures, no.
Any signs that you can see that say anything about a charity tub push or a slow-moving convoy?
No.
And did your review of the information collected on this accident reveal whether there was any trail car that was placed some distance back on the roadway to alert traffic approaching from behind to the slow-moving convoy?
No, as far as I know, I can't make that determination with just the information I have.
Okay. All right. Your analysis revealed that both the Mercedes and the Jeep were in the westbound north lane of travel. Is that correct? So this kind of, I think it's north to the lake that way, right?
Right, furthest right, the right
Yeah.
bound, once you
right
start
lane.
getting cardinal directions, I start. Furthest right bound, if you will.
Gotcha.
So.
All right. And you said that you're the one who drew this picture here, saying it's not to scale, but you're pretty confident that this is what the positioning of the Mercedes and the Jeep were at the time of the collision, correct?
With the caveat of within a few feet, again, it's an area, but not point, so don't hold me to a 1/6 of a millimeter positioning, so.
And you made that determination based on the photographs that you reviewed, is that correct?
Yes,
Because there is evidence of fluid in the roadway, basically in the center of that lane, correct?
correct.
And that would have been dispelled from the vehicles as a result of the impact, correct?
Mainly from the Jeep. It's looked to me like the radiator fluid from the Jeep, so. You
Okay,
said vehicles, I don't think any would be from the Mercedes. I think
Okay.
that was all from the Jeep.
the Jeep, which was apparently squarely within the lane, correct? Within the lane of travel, correct?
Yeah.
Not on the shoulder.
I want to make sure you didn't say
Yeah.
squirrely or
No,
squarely.
squarely.
Okay, squarely, I'm sorry, yeah, it was, squarely in the lane.
The Jeep was squarely within the lane when it struck the Mercedes, correct?
Based on what I have here, the majority of that Jeep was in the lane. There is a very, very slight possibility it could have been like their right wheels touching the fog line just based off of these photos. But the overwhelming majority was that Jeep was in the lane of travel, so.
And as I understand it, the impact of the back of the Mercedes was almost square on, right?
Nearly, yes.
Okay, so it wasn't like it was hitting the left-hand side with no impact to the right-hand side of the Mercedes, correct? It being the Jeep.
Generally speaking, yes.
Okay. And that would suggest then that the Mercedes was mostly, if not all, within the lane of travel also.
Yes.
Did your analysis reveal also that the Mercedes was traveling squarely behind the bathtub?
Can I look at the pictures again?
Oh, they're right in front of you. Yes, certainly can.
From the pictures, it would look like the tub pusher would be nearly head on in the front of the Mercedes.
Okay, so kind of right in front of the hood ornament?
Yes,
Okay.
Right.
The placement of the bathtub and the pusher then would have been obscured by the Mercedes, correct? From two traffic approaching from the rear.
the overwhelming majority of it would have been obscured. You might have seen the tub pusher's head bobbing up and down, but overwhelming majority of the tub pusher, yes, would have been obscured by the,
Basically
Mercedes.
hidden by the car that was the Mercedes that was traveling behind it.
yes.
And the collision caused the bathtub to be sandwiched between the Mercedes and the red truck that was in front, correct?
Everything that I have had to review suggests that would be the case.
Do you have a feel for how far apart the Mercedes and the bathtub were from each other at the time of the collision?
You're asking me to do high-level math here, so
Better you than me.
right. It's like trying to chew gum and ride a unicycle and hover a helicopter at the same time. I would say, based on all the crashes that I've investigated, the tub pusher for the evidence on the Mercedes would be relatively close. When I say relatively close, within 10 to 20 feet close.
Okay. And are you able to estimate how far the Mercedes was from the truck immediately before the impact?
Just based on the pictures alone, there would be a considerable distance. What I mean by considerable is, this is again, just based off my experience here, probably about 50 feet. I don't see any major crush damage on the front end of the Mercedes that would suggest it was violently propelled into the back of the truck.
Okay. Turning back to the fact of the distance between the Mercedes and the bathtub. Do you agree with me that the Mercedes was not traveling far enough behind the bathtub to provide an effective buffer from a rear-bound crash?
Knowing what I know about crashes, absolutely not, no.
So when we call it a safety car, it wasn't providing safety as a barrier, correct?
No.
Its only function in safety was potentially to alert traffic coming from the rear that there was something going on.
Yes.
Let's talk about how well it performed that function. You've already confirmed that the Mercedes would have obscured or hidden the bathtub and the pusher mostly, if not all.
Mhm.
Yes?
I'm sorry, yes,
No.
yes.
And you've also confirmed that, well, let me ask you this. Is there any evidence that the Mercedes had its brake lights engaged?
None that I can tell.
In fact, it was traveling uphill at that point, correct?
Yes.
So the likelihood that the brakes were engaged just seems unlikely considering they were traveling uphill.
The only reason I would say they could have is just from my own experience going out there, and I know I was kind of pumping my brakes while on that scene. So I don't know if I can agree with that.
Okay, but you don't know.
No,
And we don't have any evidence from the Mercedes to say whether or not the brake lights were engaged.
not that I can make a determination on.
We also don't have any evidence, objective evidence from the Mercedes to indicate that the hazards were on, correct?
Correct.
Based on all of these things, would you agree with me that the safety car, the Mercedes safety car, actually made things more dangerous in terms of this convoy's operation?
Possibly.
I mean, it didn't have anything, at least nothing that we can point to, that actually alerted traffic coming from behind to the fact that there was a pedestrian right in front of it, correct?
Nothing that I can say, correct.
And it acted as camouflage for the pedestrian in the roadway.
That's a fair assessment.
Something that might have alerted a driver coming from behind, hey, there's something weird's in the road. That was obscured by the Mercedes, correct?
Correct.
Did the way that this convoy was set up pose the risk of an accident?
Possibly.
In fact, did it create a high probability that an accident would occur?
Probably.
And that is, in fact, what your opinion is of this, isn't it?
Each crash is unique. There was what they were doing posed a increased crash risk. There might have been stuff that I can't make a determination that would have maybe mitigated that risk. But being in the lane of travel on a M28, a crash risk is gonna increase drastically. So, especially at a slow speed.
Okay, and so it did create a high probability of an accident, the way that they operated this vehicle convoy with the bathtub.
Define
I'm gonna
high.
object there, Your Honor, it's asked and answered.
It was sort of answered.
Yes, it was.
And in fact, that's what you shared with Ms.
The
Hero.
first question dealt with the high risk and then
Sorry, Your Honor.
a high probability. I mean, if those are two different things, I don't know, but go ahead.
Thank you, Your Honor. That's in fact what you shared with Ms. Hero in your conversation, correct? High probability of an accident based on this, the way that this convoy was set up.
Yes, and what I'm getting hung up on is high. It will increase. So high as in, you're 1,000,000 times more likely to get in a crash. That's drastically high, but it increases a chance for a crash. So that's why I'm kind of hesitant on that. But yes, it will increase. There is a relatively high chance of being in a crash if you're it's slow moving in a lane on a highway.
In the particular manner that this convoy was operating.
Yes.
A moment, Your Honor.
Yes.
Nothing further.
Thank you. Any redirect?
Yes, Your Honor, thank you. Does taking your eyes off the roadway for, say, 630 feet increase the risk of a crash?
Yes.
Would you say that that is a characteristic of a prudent driver?
No, that would not be.
Any indication that the convoy on the side of the road appeared suddenly in the area where the visibility is 1,300 feet?
No.
And regarding the hazards, you don't know whether the Mercedes had the hazards on, is that correct?
The hazard lights?
Yeah, that's right.
I don't know.
So in your experience as a crash investigator, if the Mercedes had not been there, would the results or the injuries sustained by the victims been different?
If the Mercedes wasn't there and the tub pusher was just in the lane,
Yes.
absolutely would have been different.
More severe, say?
Yes.
Is it against the law to drive over the speed limit?
Yes.
Okay. And would a prudent driver follow the law?
Yes.
Is there a minimum speed limit M28 westbound between Munising and Marquette?
No.
Taking your eyes off the road for 630 feet, would that constitute careless driving?
Yes.
How long, say I'm checking my rear view, how long should that take?
I know studies have shown just a quick glance might be a fraction of a second down to maybe a quarter to a half, depending on the glance and what you're looking for. But less than a second studies have shown that those glances are.
Now, in your experience as an accident and crash investigator, would you say there's a difference between adjusting your radio and looking for a song?
Yes.
And a lane of travel, briefly here, how far approximately from this?
Generally speaking, they're around 11 to 12 feet wide that's the dash center line to
Okay.
the fog line.
Okay. 11 to 12 feet. And you said, quote me within a few feet. Few, what's a few?
For this one, based on the evidence I have, 2 or 3.
Okay, choose a couple. So anywhere. from-
3.
Okay, all right. Okay. Steering prior to the crash, based on the EDR data, you said that the 7/10 or 7 or 9 degrees or something like that. Can you be more specific? How long before the crash was that 7 to 9 degrees of steering applied from center, and which way?
I would have to look at my report to refresh my memory on that one.
I think
I know it was within the last second prior to impact.
okay, that's when that steering was applied.
Yes.
And prior to that, it would have been straight. Is that what you're saying?
Straight as in 0 degrees, 1 or 2 degrees.
I see.
No more questions.
Thank you. Any final recross?
Yes, Your Honor. President Berlin, Mr. Steinhoff asked you about whether a prudent driver would take their eyes off the roadway for 600 feet. I think suggesting that Ms. Houghton took her eyes off the roadway for 600 feet. But do you agree with me that she wouldn't have been able to maintain her lane traveling up that hill if she had taken her eyes off the road for a distance of 600 feet?
I'm gonna object here, Your Honor, that's completely speculative.
Uh,
I don't think it
Respond.
is. It's a,
The defendant, or the witness is not gonna be able to tell what's in Ms. Houghton's brain, what's in Ms. Houghton's mind.
But the question was more hypothetical, and so the court will overrule the objection.
Can you please repeat it so I know?
yes, that uphill curve at a distance of 600 feet on that roadway.
Mhm.
If Ms. Houghton had taken her eyes off the roadway consistently for that length of distance, she would have not been able to maintain her lane and would have gone off the road. Do you agree with me?
Just knowing through my crash reconstruction training and again, my the safety kind of investigation I do with MDOT and county roads.
Mhm.
I know those roads are designed to keep vehicles in the lane. So there could be, depending on how that road is designed, you can take your hands off the steering wheel, and I might have done it myself just to test it, and the car still goes straight. Hands completely off the wheel. Some person could be looking straight ahead, down, juggling if they want to, but the roadway is designed to keep the vehicle in the lane of travel.
Are you suggesting that you tried that on this stretch here?
No.
Okay.
I've just.
Because it's a curve that goes uphill. So unless you have a self-driving vehicle that's sensitive to the fog line, you need to be paying attention to where you are in the lane. Would you agree?
Yes,
And would you agree with me also that the data in this case suggests that Ms. Houghton didn't perceive this Mercedes at all, basically, before the impact?
correct.
So she was able to maintain her lane between the radio and the roadway, but didn't perceive the Mercedes.
Correct.
That doesn't necessarily require her taking her eyes off the road for a distance of 600 feet or any significant length, correct?
Correct.
You were asked about minimum speed limits. MCL 257.627 indicates a person operating a vehicle on a highway shall operate that vehicle at a careful and prudent speed not greater than or less than is reasonable and proper. You familiar with that statute?
627?
Yep.
Yes, ma'am.
Having due regard to the traffic, surface, and width of the highway, and of any other condition existing at the time.
Yeah.
Yes? This Mercedes and the convoy, they were in violation of this law, were they not?
Possibly.
No further questions.
All right, thank you.
Just a couple more, Judge.
I will allow,
Well, I think if
Redirect,
the defense gets final
redirect,
recross,
yeah,
then
and then
people
I'll
should-
allow final recross. Go ahead.
Just as a point of clarification.
This is
Your
an
Honor, the
important
people-
issue. Go ahead.
Okay. You mentioned something about the maintaining the lane and the road is designed to maintain that lane. Would driving that stretch every day perhaps add weight to that? To the fact that you know the road, you're gonna stay within the lane, even muscle memory?
Could possibly.
Okay. And the curve, Shelter Bay Hill. A lot of us are familiar with that. Is it a sudden curve?
Not necessarily, no.
Okay. And based on your review of the scene and review of the photographs, does the evidence suggest that the convoy suddenly appeared?
No.
Okay. Is it your assessment that they were traveling, where they were traveling for some time?
Everything that I have suggests that.
Oh, no more questions.
All right, any final recross?
No, Your Honor.
Okay, thank you, sir. Does anyone on the jury have a question? Please write it down. Will the bailiff receive the question?
question there.
Okay.
A major question is there.
Okay. Council, I will ask the questions after consultation with council. These questions are from the jury. Is there a picture of defendant's front end of the Jeep Cherokee that you reviewed?
I believe so. That would be in that stack. I would have to review that stack.
Okay, that would be People's Exhibit number 2. I'll show you that exhibit and let you review that. And again, that's the front end of the Jeep
Okay.
Cherokee.
They were not in this stack, no.
Okay,
Um,
were there any, or can you say for sure, if you know?
The reason why I think I remember seeing a maybe partial front end was in the report I got from Mr. Steinhoff, and that had a side view of it, but not a frontal view, and that was the vehicle at the tow yard. So, but as far as if I were to go stand in front of the Jeep, looking at the front of it and taking a picture, I don't really remember one of those.
There is a rear one in People's Exhibit number 2H. But in 2H, there is not a front end picture, is that correct?
Yes, Your Honor.
Okay. All right,
I have further questioning based on that.
okay. I'll allow
May I proceed?
direct and and cross. You may.
Okay. Is this what you're referring to here?
Yes, sir.
Could you can flip that page there? Is that what you're referring to?
Yes, sir.
Okay. And is this the vehicle in question here? on the
I-
bottom of this?
I have no reason to believe that it's not. So
Which
Okay.
one? There's 2 on the page.
the bottom red Jeep Cherokee is the one that I believe is involved in this crash.
And this was appended to the data you reviewed that corresponds with this case?
Yes.
Okay. I'm gonna mark this, Your Honor, as people's proposed,
7.
we're on 8. Wasn't the CV?
CV was number 7.
Okay, so we're on 8.
Okay, thank you.
And I would move to admit.
No objection.
People's number 8 will be received in evidence.
And if I may, Judge, I'd like to publish it this time
Uh,
to the jury.
You may, with the understanding that the Jeep Cherokee in the bottom photo is the vehicle in question here. What is the top photograph relevance?
What is the top photograph?
That is a crash test done by NHTSA, the National Highway Traffic Safety Administration. They do crash tests on vehicles. And that was a picture of a 2017, I believe, a similar year, make, model that Mr. Bruno did in his report, just to illustrate that the Delta V experienced on, or the speed change experienced on the top picture was the same as the bottom picture, the Jeep in this crash.
Okay. And just quickly, Mr. Bruno is who?
He held my job before I had the job, so he was the crash reconstructionist for upwards of 20 years before I got the job. He is now retired and does some work in the civil world. So,
Your Honor, if there's no objection, I'd like to label these A and B.
No objection.
Okay.
And
And they are both depicting the same thing?
I think they're different sides of the vehicle.
Okay, all right. People's A and B again is received in evidence as A and B.
Can I publish to the
You
jury?
may. Okay. We'll let the jury review that before I continue.
May I approach the bench?
Yes, you may.
If there's a paper clip handy. So just-
I have one.
I got one. Record should show I'm appending eight A and B together and presenting to the court for application.
Thank you. All right. There are some notes on the questions submitted concerning the picture of the front end of the Cherokee. Does the juror request them back or?
I don't need them, Your
Okay,
Honor.
thank you, sir. Okay. The next question is, do you know the paved shoulder from Shelter Bay Road to Shore Drive, if it's wide enough for a vehicle to drive on?
From being out there just a few days ago, it is not completely paved enough to fit an entire car on. I think the standard is about 3 feet wide. When I was out there, about half of my vehicle was, but the left side of the tires were on the paved shoulder. I was completely over the fog line, to the right of the fog line. My left side tires were on the paved shoulder. My right side tires were completely on gravel and grass.
Does that answer all the questions?
That was not my question, Your Honor.
Okay. All right, we'll have you clarify it.
Could I please?
Yes, please,
Shelter
don't wait. You have to write it down.
Just write it,
That's what the
okay.
rules require. Thank you. And then we'll have the bailiff retrieve the question when it's done. Okay, thank you. Will council approach? I am required to modify the question somewhat. And again, I will be instructing the jury at the end of this trial to base their decision only on the evidence I let in and nothing else. But I'll ask the witness this question. Do you know the approximate width of the paved portion of the shoulder, that being anything to the right of the fog line in the direction of travel? Do you know how wide that paved portion of the shoulder is at the crash scene site?
Without going out and specifically measuring it, no, just based off of photos and personally driving in that area, I would want to say it is about 3 feet wide in that area of the crash site.
Okay, all right, that's the best I can do with that question. Thank you, though. Does anyone on the jury have any other questions of this witness? Okay, any objection or additional questions by counsel?
Nothing from the people, Your Honor.
Your Honor, just on the recently admitted Exhibit 8, this is the picture of the Jeep with the crash test simulation. Sergeant Berlin, this exhibit depicts both sides of the Jeep, is that correct? Both the driver's side and the passenger side of the Jeep Grand Cherokee involved in this accident, is that correct?
That's what it appears to be, yes.
Okay, and it appears to me that there is similar damage on both sides of the front end of the vehicle. Would you agree?
Yes.
So is that partially what led you to conclude that the hit to the Mercedes was pretty much square on, bumper to bumper?
That, those photos, I didn't do as much on those photos as I did the EDR data, but I used them in conjunction with the EDR data, those photos along with the EDR data.
Okay, and they are consistent, correct?
Yes.
All right, nothing further.
Okay, all right. Thank you. You may step down, sir.
Thank you, Your Honor.
Next witness.
People call Dr. Perez.
Thanks.
Yes.
No, you can take that. Okay. Thanks for coming down. Appreciate it.
Please come forward, sir. Here. Just raise your right hand as best as you can. You solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth.
Yes.
Please be seated, sir. You may proceed when you're ready, Mr. Steinhoff.
Thank you, sir. Sir, could you state your name and spell your last for the record?
Ryan Fick-Perez, Dick-Perez.
Thank you. And where do you work, sir?
UPHS Marquette.
Okay. And what do you do there?
Emergency room physician and
Okay.
ICU physician.
So what should I call you?
What's that?
I should call you Dr. Dick Perez?
Sure, Ryan's fine. I don't care.
Let's go with doctor for the
Okay.
purposes of these proceedings.
Okay.
How long have you been a doctor?
Total, I graduated medical school in 2012.
Okay. Do you, and I kind of want to jump right into things here. Do you know an individual named Stephen? Are you familiar with an individual named Stephen Bruzzese?
Yeah, I don't remember much, but I just reviewed the case when I got the.
Was he a patient of yours?
subpoena. Yes.
And do you, based on your review and based on your memory, could you recall the circumstances in which you came into contact with him?
I believe I saw him as he was in an accident, and it's from what I remember. And yeah, I came into contact him in the emergency room.
Okay. And could you describe his appearance when you first saw him?
I can't recall exactly. I can just recall kind of from what I gathered from my notes.
Okay, and so let's go into those then. Did you treat the patient?
Yes.
Okay.
Yes, I was one of the treating.
And what did you treat him for?
He came in as a trauma. We treated him for his injuries. He had a pneumothorax or collapsed lung. I don't recall which side it was on.
Okay.
And he had some traumatic brain injury.
All right, let's start with the, say it again.
Pneumothorax. yeah.
Pneumothorax, okay. Collapsed lung, what does that mean?
Basically there was some injury to the lung that caused it to collapse so that there was air between the lung and the chest wall.
Okay, and pretend I don't know anything which is about this, which is not far off the truth.
Okay.
It's medical. Does a collapsed lung work appropriately?
No,
Okay,
no, it does not.
is a lung an organ?
Yes.
Okay. And what kind of treatment do you do what did you do for it?
We ended up putting a tube in his chest tube,
Okay. And why would you do that?
just to pull the air out that was between the lung and the chest wall to reinflate the lung and then kind of removing air while the lung was able to heal.
Okay. Just putting the chest tube in the chest. Where do you put the chest tube in?
Kind of right in the axillary region.
Okay, kind of by the armpit?
Yep.
Okay. Does that get it working again?
Get the lung working again?
Yeah.
Yes.
Okay.
Yes.
And you said a traumatic brain injury. How did you know that?
Well, just he was quite confused, quite repetitive when he came in. From my notes, like I said, I'm not recalling this from memory. This is just from what I reviewed from my notes.
Okay.
But I documented that he had what we call a GCS, a Glasgow Coma Scale, which is kind of a judge of traumatic brain injury. His was slightly decreased. I think his was 14, normal is 15. And he was documented to be repetitive. So asking the same questions over and over again.
Okay.
Loss of short-term memory.
Was that loss of memory, interruption, brain activity as a result of hitting his head on something?
That would be my assumption.
Okay.
I don't remember an alcohol or a tox screen.
Okay. Was he, do you recall if he was in pain?
No, I don't.
And was there any medications ordered for him?
I don't recall.
Do you have the chart with you?
I don't know. I didn't know if I was supposed to bring that or not.
Okay. So let's talk more about the collapsed lung, and then we'll talk a little bit more about the TBI. How do you treat after the initial chest tube? How do you treat a collapsed lung?
So we put the chest tube on suction, so we pull negative pressure on it. We watch it. Once the lung reinflates, then we take that negative pressure away and just leave it on a seal. And then we get some follow-up chest x-rays, make sure it didn't collapse again. And then if it hasn't collapsed again, we eventually pull the chest tube out, usually a couple of days later, and
Okay,
then reevaluate to make sure the lung didn't collapse again.
okay. And how long does it take? You said a couple days later. How long before that lung is working appropriately usually?
It depends on what the injury to the lung was, but generally they start, as long as there wasn't significant trauma directly to the lung, they generally start working almost immediately.
Okay.
Back to their normal function.
And for a TBI like the one you saw in Mr. Bruce's, how long does the effects of that?
They can have kind of, I'm assuming that he had a concussion. I don't know if he was ever diagnosed with one. He didn't have any evidence of brain injury on imaging, on CAT scan. So this is just, I'm just assuming from a concussion, so that's what I'm going to speak to.
Okay.
But symptoms from concussions, post-concussive syndrome can go on for months sometimes before someone, and other people tend to heal up quite quickly and nobody really understands why.
Okay, all right, no more questions for this witness.
Thank you. Cross-examination.
Just have a couple, Dr. Firth.
Yeah.
The TBI is the thing I'm most interested in.
Okay.
Your notes or the records that you reviewed indicated that Mr. Bruce was repetitive in asking questions, asking the same question over and over. Yes?
Yes. Yes.
So did that suggest to you that he wasn't remembering that he had already asked the question and he received an answer to it?
Yeah. Yeah. So loss of short-term memory.
Okay, and that short-term memory loss, that's something that could have impacted the, what had happened at the scene of the accident, would you agree?
Yes. Certainly.
And it can also affect memory of what happened before the accident occurred, correct?
There's patients can either have kind of antegrade or retrograde amnesia.
Mhm.
They don't necessarily have both, but they can have both. Yes.
Okay,
And
And that's not
retrograde
something-
would be before.
sorry,
The retrograde amnesia would be
before.
events before the injury.
Okay, and you didn't do any kind of analysis to determine whether or not Mr. Bruce had retrograde or the other one?
No. I'm just completely assuming that from his repetitiveness and the diminished GCS, which was all antegrade symptoms. So after the incident.
Okay. It's possible that he also had loss of memory of what happened before though, correct?
It's possible, yes.
And just because a traumatic brain injury doesn't show up on a CT scan or other imaging doesn't mean that it's not an actual thing. It actually can be without physical evidence, correct?
Yeah, so kind of the definition of a concussion is in normal imaging with exam findings consistent with a traumatic brain injury.
Nothing further.
Any
Thank you.
redirect?
No, Judge, thank
Does
you.
anyone have any questions on behalf of the jury? Okay, thank you. All right, did you have a request?
I request that this witness be excused.
Any objection?
No, Your Honor.
You are excused.
Thank you.
Thank you, Doctor.
I have another request, Your Honor, and that would be for a recess.
Okay, well, it's a good time to take one. We'll recess until 10:30 sharp. All rise. May return to the jury room. Court will be in recess. We'll be back in session. We'll bring the jury out at this time. Please be seated. You may call your next witness.
Thank you, Your Honor. People call Brendan Summer.
Up here, please.
Please raise your right hand, sir. Do you solemnly swear the testimony you're about to give in this case will be the truth, the whole truth, and nothing but the truth?
I do.
Please be seated. You may proceed when
Thank you,
you're
Judge.
ready.
Please state your name, sir, and spell your last.
Brendan Summer, Sommer.
Okay, and where do you, in general, where do you live now, or where'd you come from today?
I came from Marquette.
Okay. And what do you do there? What do you do?
Well, for right now, I am a student at Northern Michigan University. I work for the NMU Police Department as well as a lift operator at the Marquette Mountain. But I also serve in the Army National Guard down in Gladstone.
Okay. And let's go back to November 2nd of 2019. Where were you living?
I was living in the on-campus apartments. I don't remember the exact address.
In Marquette?
In Marquette,
Okay, and as a student, is that right?
correct.
Were you in the National Guard at that time?
I was prepping for basic training at that point.
Okay. Back on that date, were you involved in a traffic crash?
Yes.
Okay. And just a little bit of the background here. What do you remember from before the crash that day?
That day, I remember waking up early, meeting the convoy just outside of Munising.
Mhm.
And don't remember much leading up to the crash itself. I just remember looking up in a rearview mirror, and then next thing you know, I'm running around trying to help as much as I can.
Okay, and as it relates to this convoy, where were you situated in the convoy?
I was in the lead car.
Okay, do you know what kind of vehicle that was?
I just remember it was a red truck. I don't remember the make or model.
Was it yours?
No.
Oh, okay. And this is for the tub push?
Yes.
Okay, all right. And could you describe where everyone else was at the time of the crash?
So it was me and 3 of my brothers in the lead car.
And I want to stop you right there and ask you, what do you mean by that? What do you mean by brothers? Is this one big family?
Overall, I have a good family in the fraternity, but they're my fraternity brothers.
Okay, okay. So you're not your blood
No.
relations, they're your fraternity brothers.
They're my fraternity brothers.
All right, please continue.
And then behind was the tub being pushed by Leo. And then behind him was the, I want to call it the chaser car. And it had Dan and Steve in it.
Okay. And you said you looked into your rear view mirror. What did you see?
I saw a vehicle coming up, and at first didn't think much of it, like, because we've been seeing cars pass us almost the whole route.
Okay.
But I just glanced up, saw a vehicle coming, and went, okay, another vehicle gonna go by us, and then happened.
What happened?
The crash happened.
Okay, okay. And as far as the convoy is concerned, do you remember where you started from that day?
It was just outside of Munising, but I don't remember exactly where.
Okay,
When I got on for it.
all right. And you're from, originally from where?
Originally from Midland, Michigan,
Okay, so a few hours away from here.
a few hours away, yes.
Yeah. Okay, and let me ask you this. As far as safety precautions for this kind of event, were the hazards on the vehicles on?
Yes,
Okay. Were the hazards on the red truck on?
yes,
Were the hazards on the white Mercedes on?
yes.
Okay. Now, directly after the crash, what did you do?
I got out of the truck and I just remember running to make sure that no one was severely injured. But it was a big adrenaline rush, so I don't remember any details from it.
Okay. Were you injured at all?
No.
Okay. Now, prior to the crash, do you recall where in the roadway where the whole thing was?
I truly don't remember. I just remember being as far to the right side as I could.
Okay,
That's truly all I remember.
okay. And was it your goal to stay close to the
Yes.
side of the road? Okay. And subsequent to the running around and seeing who was hurt, who wasn't hurt, what happened after that?
After that, I just remember being told by an officer, we'll be in touch if we need any more information. And I just remember crying in the car on the way home.
What were you upset?
I was just more scared than anything.
Right, okay. Did people go to the hospital?
Yes.
Okay, all right. No more questions for this one.
Cross-examination.
Mr. Summer, I understood Mr. Steinhoff's question to you previously to be that, did you remember anything, or what did you remember about what happened leading up to the accident? And you said you didn't really remember anything. Did I hear that correctly?
Don't remember a whole lot, but yes.
So you're agreeing with me that you really don't remember much up till when you looked in your rearview mirror and you
Correct.
saw a crash about to happen?
Correct.
And it sounds like it was pretty chaotic afterwards.
Yes.
You knew at the time you were trying to render assistance that it was a serious traffic accident, correct?
Correct.
And you saw that your fraternity brothers, a couple of them, were pretty significantly injured, especially Leo, right?
Yes.
It sounds like it had a pretty big impact on you.
It frightened me a lot.
It frightened you a lot, even to the point of tears on the drive home.
Correct.
Do you agree with me that you were under some pretty considerable stress at that time?
During the, which part?
During the time when you were trying to render assistance and worrying about your fraternity brothers?
Yes.
And you were the one who was in charge of driving the lead truck, correct?
Correct.
You were the one who was in charge of whether the hazards were on in your vehicle, correct?
Correct.
You weren't in charge of what was going on in the Mercedes?
No.
Did your truck have a plow light or a bar light or strobe light, anything on the top of it?
I do not remember.
Okay. Were you the one who, was it your truck that you were driving?
No.
Okay. And you don't recall having taken any action to put any special lighting, to turn any special lighting on that car, the truck?
Other than the hazards, no.
And how far ahead of the convoy were you driving? Can you estimate the distance between, say, the bathtub and the truck?
I truly don't remember the distance. To be quite honest, I don't remember how far away. I say it was at least 15 feet. We tried to keep that.
You have no way to really confirm whether or not the hazards were on the Mercedes, do you?
I don't.
And you've been participating in this event since several hours before, is that right?
That is correct.
And you would stop periodically during those few hours to switch drivers and
Yes,
take little breaks, correct?
correct.
It's possible that the hazards were turned off on the Mercedes at some point, isn't it?
I mean, potentially, but I can't say if they were or not. I just remember being told to keep on the flashers.
But you don't know that that actually happened, that they were on at the time of the collision.
I don't recall.
Moment. No further question.
Thank you. Any redirect?
Yeah, Judge, just a couple. One thing I continue to forget to ask, how old are you now?
I am now 23.
Okay, and how old were you November 2nd, 2019?
November 2nd of 2019. Why am I blanking on this? I was 21.
21, something like that anyway.
I recall.
Okay, and regarding the flashers, you said you were told, was there some kind of an agreement that the flashers would be on ahead of time? Okay, all right. And was that the usual course of things?
Correct.
Okay, no more questions.
Any final recross?
No, Your Honor.
Does the jury have any questions of this witness? Okay, thank you. You may step down, sir. Next witness.
And Your Honor, I regret that. Can he be excused?
Yes.
You can take off.
Okay, you are excused. Thank you.
Sorry, you can go on. I have to check, Your Honor. I regret that I have to beg another recess here. I'm not sure if our next witness has arrived yet.
Okay, all right. Let the,
Maybe a couple minutes.
all right, okay, we'll take a recess until 10:50. Will that give you enough time?
Yes, Your Honor.
Okay, all rise. Return to the jury room. Court will be in recess till 10:50. Court being back in session, we'll bring in the jury at this time. Please be seated. You may call your next witness.
Thank you, Your Honor. People call Deputy Eric Brock.
Deputy Brock, will you raise your right hand?
Yes.
Do you solemnly swear that the testimony you're about to give in this case will be the truth, the whole truth, and nothing but the truth?
Yes. Yes.
Thank you. You may proceed when you're ready, Mr. Steinoff.
Thank you, Your Honor. Could you spell your name, sir, or say your name and spell the last, rather?
Eric Brock, Brock.
And where do you work, sir?
The Eldridge County Sheriff's Department.
And for how long have you worked there?
9 years.
Okay, and what do you do there?
A little bit of everything, I guess. It's kind of work in the jail, dispatch, and patrol.
Okay, so are you a certified police officer?
Yes.
And quick housekeeping matter for the benefit of the jury. Why are you on the screen and not here in person?
Due to COVID.
Due to COVID. Do you have COVID?
I do.
Okay, and well, thank you for being here, that notwithstanding. Your regular duties as a patrol officer, what are those?
Enforcing traffic laws, responding to complaints, all sorts of different things, I guess.
And as of this date, how long have you been a certified police officer?
Since 2019, August of 2019.
Okay, so I want to take you back to November 2nd of that year of 2019. Is it fair to say that you had been a certified officer for 3 or 4 months?
Yeah.
Okay. Now, speaking of that date, November 2nd, 2019, were you on duty?
I was.
And were you on duty with anyone else?
Yes, Sergeant Peters at the time, now Lieutenant Peters.
Okay, and it's true that is it true that you're the investigating officer as designated for this case?
Yes.
Okay, and you've seen, were you listening or did you see Lieutenant Peters' testimony?
I was watching, yes, I was listening.
Okay, very good. And the incident that was mentioned,
I can't hear anything.
Okay, one moment. Sit.
and just for the benefit of the witness, we're having some technical issues. Not on your end.
Okay.
Okay, please proceed.
So, again, did you respond to the incident that was referenced by Lieutenant Peters?
Yes.
Okay, and what did you do when you arrived on scene?
Basically just trying to check on everybody involved, see who was hurt, who wasn't hurt, what kinds of injuries, you know.
Okay. Okay. So in that vein, knowing a little bit about the Alger County setup, were you wearing your law enforcement hat or your EMS hat when you arrived?
Law enforcement.
Okay, so
I'm
were
not an EMT.
Okay. And as soon as you arrived, did you or Lieutenant Peters move any of the individuals?
No, I don't believe, no.
Okay. And I want to talk a little bit about the venue.
Shelter Bay Hill. Are you from this area, Deputy Brock?
Yes,
Are you familiar with Shelter Bay Hill?
yes.
Okay. And based on your familiarity and experience, how long of a hill is it?
I don't know, guessing a couple miles probably. Between a mile, 2 miles,
Okay.
pretty long.
And okay. And the weather on the date in question, that being November 2nd, could you describe the weather?
It was sunny. I don't know, it was pretty warm out
Okay.
for November.
And did you take photographs of the scene?
Yes.
Your Honor, may I approach the bench?
You may.
Deputy Brock, I'm gonna show you what in this room we call People's Exhibit number 2. It's A through J. I'm gonna show you A, B, and C. You see that photograph?
It's quite blurry, but I can see the white car. It's like, yeah, I know what it is, but it's pretty blurry.
Okay. Did you take that photograph?
I did.
I'm gonna return this to the bench.
Okay, go ahead.
Did you take any photographs, other photographs of the scene after the event? Or at around the time of the event?
I guess I took several photographs.
Okay, I'm gonna show you what we call People's Proposed 1. And did you take this photograph?
That's not of the accident scene, is it? It's hard to see. It's pretty blurry.
All right, that's okay. Let's forget about that.
That has not been offered in evidence, number one.
I know, Your Honor, and it's
Okay.
I'm gonna withdraw that as an exhibit.
All right, okay, thank you.
Do you recall what time of day you responded to this incident here?
Like late morning, around
Okay.
11.
And you heard Lieutenant Peters testify about the time. Do you know the time that it took to get from where you were to the crash?
We were in a train. It probably took, I'd say, under 10 minutes.
Okay. And just for the benefit of the jury, is Forest Lake, Autrain, are they kind of the same thing?
Sorry, what's that?
Forest Lake and Autrain, are they somewhat the same thing?
We were on Forest Lake Road in Autrain.
Okay. I see. Okay. And kind of skipping around here, did you have contact with the defendant at the scene?
I did.
Okay. And could you describe her emotional state?
Very upset.
Okay. And we saw the body cam that corresponded with Lieutenant Peters. Whose decision was it to cite the defendant for careless driving?
Both of ours. We kind of agreed on it. Thought it was fitting for what happened, I guess.
Okay. And who ultimately issued the citation?
I remember writing it. I believe Lieutenant Peters issued it, but I don't quite recall.
Did you indicate on this? Did you indicate on this ticket here, like when it should be paid by, if responsibility was being admitted?
On the bottom of the ticket, we would have wrote, would contact court or take care of within 10 days.
Okay, is
That's
that your
pretty
usual
standard.
procedure?
Yeah, it's pretty standard.
Did you subsequently appear for a formal or informal hearing concerning this?
No, sir.
Your Honor, may I approach for number, I don't remember. What number we're on. the one this morning, one before that. This one.
Yes, yeah.
Now this may be difficult to see. It's People's Exhibit 6. Do you
I cannot tell what that is. I can't make any of that out. It's
the age of
pretty
COVID.
blurry.
You know what, Leonard? I think to do this, I'm going to request to publish Exhibit 6 to the jury.
All right. You may do so at this time. And we'll wait until all the jurors have seen it.
Stand by, Deputy Bragg.
Yep.
May I push the bench, Your Honor?
You may. Thank you. And for the record, the People's Exhibit number 6 was a certified copy of the Register of Actions in the careless driving citation subject to this case. You may proceed.
So, Deputy Brock, at this point, you may not have noticed, because the jurors are not on screen, but the jurors have reviewed the Register of Actions in the civil infraction case. Why did you issue a citation? Why was the citation issued for careless driving?
Based on her interview with her, she said she was adjusting the radio, not really looking up ahead of her when the accident occurred.
Did the fact that she crashed into a group of a convoy on the side of the road play any role in issuing the careless driving?
Yes.
No more questions.
Cross-examination, Ms. Harrell?
Thank you, Your Honor.
You're welcome.
Hi, Deputy Brock. Can you hear me okay?
Yes.
You and Lieutenant Peters arrived together in the same vehicle at the scene involving the fraternity group and Miss Houghton. Is that right?
Yes.
And Lieutenant Peters almost immediately took on the role of a medic, and you took the role of a lead police investigator. Is that right?
Correct.
Did you know that Lieutenant Peters was available to you for any questions with your being the lead police officer?
Yes, of course.
And you chose to write Ms. Houghton a ticket for a civil infraction, careless driving.
Correct.
And the incident was investigated as a civil infraction.
Correct.
And you didn't preserve evidence here like you would if it was a crime scene.
Correct.
You didn't call for an accident investigator to preserve the scene or anything like that.
We did not.
You and Lieutenant Peters passed the fraternity earlier in the day, is that right?
Yes.
Well, let me ask you this, because it seems like it hasn't clearly been described for the jury. On Shelter Bay, November 2019, the speed limit was 65 miles an hour, is that right?
Yes.
Okay, so when you and Lieutenant Peters passed the fraternity group, were you guys opposing traffic? Were you opposing them? Or did you pass them? Like, same direction?
We went by them. Honestly, I don't remember where or what direction we would have been going. I don't recall. But I do remember seeing them at some point before the accident.
When you passed them, you didn't notice any emergency flashers on the Mercedes or the truck, is that right?
I don't remember seeing any flashers, no.
No signage along the road?
Nope.
And you didn't notice any trail car set back a ways alerting traffic that there's something unusual in the road?
No.
People, when they are issued civil infractions, can submit payment through mail to the court to pay their civil infraction ticket. Is that right?
I believe so.
You don't have to go to court, right?
I don't believe so.
And just because someone is issued a ticket for a civil infraction does not mean that they're guilty of it. Is that right?
Correct.
And many people actually don't contest civil infractions. While they might otherwise feel that they disagree with the civil infraction, they will just pay it anyways. Is that right?
I suppose I'm not entirely sure on that.
Do you know how fast the fraternity group was going?
Walking speed, I'd assume.
Deputy Brock, are you familiar with the Michigan Vehicle Code 257-627 labeled speed limits?
I believe so. I'd have to refer to it, I suppose.
It says that a person operating a vehicle on a highway shall operate that vehicle at a careful and prudent speed, not greater nor less than is reasonable and proper, having due regard for the traffic. Do you think that going walking speed is an appropriate level of speed in a 65-mile-an-hour zone?
No, I would say no.
So it's fair to say that the fraternity group was in violation of this law?
If they were in the traffic lane, I would say so.
No further questions.
Thank you. Any redirect, Mr. Steinhoff?
Yes, Judge, thank you. And earlier in the day, you said that you don't remember seeing flashers. Does that mean that the flashers were not on?
I can't answer that. I don't know if they were on or not on. I don't recall.
Right, and in fact, you don't remember which way they were going. Is that right?
Right.
Okay. So the flashers being on, would that mitigate the danger, the potential danger, I suppose, of operating a charity event?
I'm unsure.
Well, let me ask you this. What are the flashers designed to do?
Grab people's attention.
Right. Okay. And at the time of the incident, the time you encountered all of these people, were you aware of the extent of the totality of the injuries of anybody?
You mean prior to our arrival, were we aware of the extent of the injuries?
Prior to or even after, did you do a complete medical examination to find out the extent of the injuries of anybody?
We knew the injuries were pretty severe, but as far as the extent, no, we wouldn't have known that.
Okay, very good. One moment, Your Honor.
Yes.
When you issue a citation, do you take into account the totality of the circumstances?
Yes.
And you use that information to decide who to cite, is that correct?
Right.
Okay.
Yeah.
All right. No more questions, Judge.
Any further final recross?
No, Your Honor, thank you.
Okay, thank you. Does anyone on the jury have any questions? We do, and the bailiff isn't here. Mr. Steinhoff, could you grab the line?
If the court would allow.
Any objection?
No, objection.
Okay. Record should reflect that I'm approaching juror number 6, taking a piece of paper. Record should show I'm not reviewing the piece of paper and I'm presenting it to the court at this time.
Okay, thank you. I'll review that. Okay, will counsel approach, please? I'll let you read the questions. There's several questions here. I'll ask the question. I will paraphrase it somewhat. Deputy Brock, did you obtain any records or have any information concerning whether there was any admission from the defendant concerning whether a phone was being used or there was any texting going on at the time of the crash?
No, I remember she told me she was adjusting the radio, I believe.
Okay, but there was no reference to a phone, is that correct?
Correct.
Okay. And you didn't conduct any independent investigation of her phone to determine whether that was true?
No, sir, we did not.
Okay, does that answer the question? Okay, thank you. Any other questions from the jury? Apparently not. Do you have any other redirect based on that line?
Nothing from the people yet, Judge.
Do you have any Ross?
No, Your Honor, thank you.
Okay, that'll complete your testimony, Deputy Brock. Thank you.
Thank you.
Any further witnesses?
Your Honor, we have one more witness, and I regret that the individual has been subpoenaed for 1 o'clock. We are moving along at a fair clip here. Testament, I think, to the litigants in that regard, and to the court for keeping this thing moving at a fair rate. But I'm not ready to proceed until 1 o'clock. I can try to call and see if I can hurry this person up, but they are medical professionals, so it may.
Okay, and what is the name of the witness?
Jarrett Sadler, Your Honor.
Okay, we'll recess until 1. It's almost lunchtime anyway, so you'll have an hour and a half for lunch, members of the jury. Report here back just before 1 o'clock, and we'll start at 1 o'clock sharp and conclude.
Thank you, Judge.
All right. Please don't discuss the case with anyone or let anyone discuss it in your presence. You may return to the jury room at this time and then leave from there, and we'll see you at 1 p.m. Thank you. Court's in recess. Mr. Ruiz, are you on Zoom at this time? Mr. Ruiz? Can you give Mr. Silta that advice of rights form, and it's a good time.
You what?
Can you grab that form right there for him, Mr. Silver?
Yeah, Mr. Silta, I'll give you time to read this form. I'll be asking if you've read and understood all the rights listed on that form.
Oh, there he is.
Mr. Ruiz, can you hear me?
I can, Your Honor.
Okay, and Mr. Silta, if you could please have a seat there in that chair. This is file number 216071, People versus Craig John Silta. This matter had been set for preliminary exam, but its exam was adjourned at one point, but it's my understanding the parties are here to waive exam. Is that correct, Mr. Ruiz?
That's correct, Your Honor. I talked to the prosecutor. We're going to waive examination. I believe the prosecutor's going to stipulate to reinstating bond.
All right. We'll cover that in a minute. Mr. Silta, please stand and raise your right hand. Best as you can. Do you solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yeah.
Please be seated. Please state your full name.
Craig John.
Is your mailing address Post Office Box 12, Ternary, Michigan?
Yes.
And what is your date of birth?
11/23/70.
If it is your desire to waive preliminary examination, I'd ask that you sign this document. It states that you understand that you have a right to employ an attorney, that you may request a court-appointed attorney if you're financially unable to employ one, that you understand that you have a right to a preliminary examination where it must be shown that a crime was committed and that probable cause exists to charge you with that crime. By signing this document, you're voluntarily waiving or giving up your right to the preliminary examination. You are agreeing that your case will be bound over for you to appear in circuit court on the charges in the complaint. Captain Waldron, will you see that the defendant? Are the people also waiving?
People likewise waive, Your Honor.
Okay. Right there, he has to sign. Right there. We need Mr. Steinoff to sign that too. And if you have the information, I can take that at this time.
Your Honor, I'm actually going to write in the TCN number on the information. Oh, maybe I'm not. You know what, we'll file an amended with TCN. So the information does not have it.
There is a CTN here.
There's a CTN, but we need the TCN.
Oh, TCN, okay.
Can I approach, Your Honor?
Yes, you may.
Tender to the court the signed felony information. For the benefit of Attorney Ruiz, it reads the same charges that are listed on the felony complaint that was in district court. We waive reading of that document.
Well, the court determines examination has been voluntarily waived. Defendant shall be bound over to appear in circuit court in a moment on the charges in the complaint. I'll address bond in the arraignment for circuit court. Okay, this is a special session of the 11th Judicial Circuit Court in the matter of People versus Craig John Silta. This will be Circuit Court File Number 212491 FH. Is there a waiving of the reading of the information? I think you said the people would.
People waive, Judge.
Does a defense waive reading?
Defense would waive reading, Your Honor.
In short, Mr. Silta, you're charged with OWI third offense. That's a felony that carries penalties that I've explained to you before, and resisting, obstructing a police officer, count 2, and habitual offender third offense that doubles the penalties to each of these charges. Do you understand what you're charged with and the possible maximum penalties?
Yes.
To that charge, you have a number of rights. Did you receive the advice of rights form?
Yes.
And did you read and understand all the rights listed on that form? And did you sign and date it?
Yes.
Okay, Captain, we'll take that for our court file. To the charges contained in the information, you have the right to plead guilty, not guilty, or stand mute and say nothing. If you plead not guilty or stand mute, I'll set the matter for further proceedings. If you plead guilty, you'll be giving up all the rights listed on the advice of rights form, and there will not be a trial of any kind. If you are on probation or parole for any offense, a guilty plea could be a violation of the probation or parole. Mr. Ruiz, what plea does the defendant wish to offer at this time?
Not guilty, Your Honor.
We'll set the matter for pretrial before the 11th Judicial Circuit Court. Ask the parties to contact the assignment clerk for a date and time. Anything concerning bond at this time that we can address?
Your Honor, there has been a stipulation to reinstate Mr. Silta's bond. He has been lodged for a considerable amount of time, based on a non-appearance due to a mix-up, close to a month, Your Honor. I did talk to Mr. Silta. He can give the court an update, talk to him about some ways that we can make sure that he gets his mail. Now that we're in circuit court, I will make sure that I keep him apprised of court dates. During the time that this he had missed, there was also a change in counsel. It went from the PD's office to my hands. So, Your Honor, I think that enough.
If there's a stipulation, if there's a stipulation on bond, the court will follow that. What is the agreement?
To reinstate the previous bond, Your Honor.
All right. And that people are in agreement with that?
Your Honor, that is an accurate statement. We are in agreement to reinstate the bond. For the record, the purposes of this agreement are the fact that the defendant's reason for the bond getting revoked were relatively minor. We have a non-appearance. With a stated logical reason, I'd ask that the court reiterate the bond conditions of no assaultive or threatening behavior towards anyone and comply with the lawful orders of police.
The court will reinstate the original bond. That states 10,000, 10%. Defendant must appear at all court proceedings, keep in contact with his attorney. There are a number of conditions of the bond that include no use of alcohol, marijuana, or any illicit controlled substance. Participate in a substance abuse testing or monitoring program, SoberLink, and then also no assaultive, threatening, or intimidating behavior toward anyone. That wasn't apparently on the original bond, but I'm adding that at this time. Okay. Mr. Ruiz, will you see that the bond is completed? And I think it's already been posted, so the defendant can be released. Mr. Silta, check your mail regularly so there's no mix-up on the bond, and stay in touch with your lawyer. Anything further at this time?
Just not on this file, but I beg an additional 5 minutes. I wasn't anticipating this today,
Okay.
so I need 5 more minutes after 1 o'clock.
All right.
And Your Honor, he'll have to pay that $300 overlay fee.
Okay, all right, well, the fees go with it, yes. Okay, thank you. I'll give you till 1:05 and we'll commence court at that time on the trial. Court's in
Thank you, Your Honor.
recess. Thank you, Mr. Ruiz. parties ready to proceed?
You are prepared, Judge.
Yes, Your Honor.
Defense ready? Okay, we'll bring in the jury at this time. Court will be back in session. Please be seated. You may call your next witness. Please come forward. Raise your right hand. Do you solemnly swear that the testimony you're about to give in this case will be the truth, the whole truth, and nothing but the truth?
I do.
Please be seated. You may proceed when you're ready, Mr. Steinhoff.
Thank you, Your Honor. Could you state your name and spell your last name?
Jarrett Sadler. Last name you want me to spell? Sadler.
Okay, and where do you work?
I work at Active Physical Therapy in Marquette.
Okay, and in November of 2019, where did you work?
I was still in graduate school, did not work.
Okay, you were still in graduate school at the time?
Correct.
At that time, were you employed anywhere?
No.
Did you have sometime after that, did you have an association with an individual that you could say?
I did, yeah.
So what was the nature of that relationship?
So it would have been February of 2020, in which he came in for initial evaluation following a car accident.
Okay, and what did he present with?
He had pain in his thoracic spine, some pain in his lower back. Yeah, and that's what we eval'd him for, and then subsequently treated him for.
I noticed when you said that you put your hand here.
Correct.
What were you doing there?
That would have been the region in which he described where he had the pain.
Okay. And is that pain, in your experience, consistent with the injuries that he sustained?
Yes.
Okay. And what did you do for him?
Well, there's various techniques and stuff that can be offered, but so we use manual therapy techniques, which was hands-on stuff, joint mobilizations to the thoracic spine and to the lower back. And then there was therapeutic exercise and neuromuscular re-education, which are a variety of exercises that were provided to try to alleviate the discomfort in his thoracic spine and enhance mobility, etc.
Okay. And for how long did you treat Mr. Brzezinski?
I treated him or was involved in the plan of care until July of, I believe it would be 2021.
2021?
2020, sorry. Yeah.
Okay. So you were with him for approximately 8 months after the accident?
Yes.
Okay. All right. That's all I had for this witness, Judge.
Okay, thank you. Any cross-examination?
No, Your Honor, thank you.
Does anyone on the jury have any questions of this witness? Okay, thank you, sir. You may step down. Are there any objections to excusing this witness?
None. Excuse me, Judge. No.
Okay, thank you. Any from the defense?
No, Your Honor.
You're welcome to stay with us or free. Next witness. I'll let you recover.
Thank you, Judge. I had an incident with this water. The people rest, Your Honor.
Okay. Cases with the defense. Does the defense call any witnesses?
No, Your Honor, the defense rests.
Okay, thank you.
There are no rebuttal.
Okay. Of course. Thank you. I know that we just reconvened, but we're going to take a break. There's some paperwork we have to prepare, and then we'll be right with you. Please don't discuss the case yet. We need to have closing arguments, and then we'll give you your final instructions in this case. All rise. You may return to the jury room at this time. Please be seated. I would like to meet with council and chambers for a pre-instruction conference and any other matters at this time from either party.
There's nothing that I'd like to put on the record, Your Honor.
None, Your Honor.
Okay, thank you. We'll do the pre-instruction conference and then I'll give you some time to gather your thoughts for a closing statement, argument. But we'll get the instructions done first and then go from there. So I expect that will be out about 15 minutes total. Court will be in recess. The party's ready to proceed with closing arguments.
Yes, Your Honor.
Yes, Your Honor.
Okay, thank you. I'll just have those, you hold on to those for now. You may bring in the jury. Please be seated. Court will be back in session. Mr. Steinoff, you may make closing argument.
Thank you, Judge. And thank all of you for sticking with us. Heather and I have been watching you, unsurprisingly, for the last day and a half. And you looked attentive the entire time, paying attention, and we certainly appreciate that. That shows that you're taking it seriously. And on behalf of the citizens, we are certainly grateful. So, why are we here? We're here because the defendant's conduct meets a pre-prescribed set of elements set forth by the citizens that constitute a criminal act. That's why we're here. So what are the facts? How do we get to that point? And this trial, in general, is somewhat unique in that there are relatively few contested facts. Everyone agrees that the defendant crashed into this group as they were on the road or on the side of the road, what have you. And I'll get into that and relevance to that. So recall yesterday, just recapping some of the things that we've talked about. Lieutenant Peters, she was on the screen there, and she was really the field marshal of the scene after the crash had happened. As soon as she arrived, 20 years of experience in the sheriff's office, she's a paramedic. She's a licensed police officer. She's a deputy emergency manager. She's got all kinds of things going on. I'm glad she was the one that was in charge because it was abundantly clear she knew exactly what she was doing. You know, boom, you go here, Eric, you do this, Eric, you do that, or you do this. And then all while she was holding ceasefire the entire time. She testified that her primary role was EMS. That's the mode she was in when she arrived. She said that in Alger County, people that work in the sheriff's office often do that. They often are police officers and EMS. First thing she did when she arrived was to assume ceasefire on the victims who had the worst injuries, which means, you know, you saw her down on her knees with Leo's head in her hands, keeping it straight for medical reasons. But the next thing she did, after about 20-25 minutes of that, we watched the whole video, was interview the defendant. And you've heard over and over the words, "I was adjusting my radio." That wasn't exactly what she said, or that wasn't all that she said. I was adjusting my radio to try and find a song. This wasn't the matter of, it wasn't as simple as hitting your preset number 1 or number 2. This was, and then she said, "This was my fault. This was my fault." After Lieutenant Peters testified, you saw Leo Majorana on the stand. Student NMU, has been a student for the last 2 years. He was calm, collected, even after his life got kind of flipped upside down by this. His testimony, coupled with Lieutenant Peters, gave us a real vision of the scene. And seeing that video really showed us what happened and how it happened and how it all played out. I think as far as uncontested facts go, the top of the list should be that Leo Majorana suffered a serious injury, shattered his legs, had a concussion, and a slip disc. The kid had to relearn how to walk after his legs were shattered. And Dr. Hendren, who was qualified as an expert, talked a lot about,
what do you do about that, how that happened, how the victim presented when he arrived in the emergency room. And his testimony was quite credible, given his experience and his articulate nature in his memory. That same day, that being yesterday, we heard from Stephen Bruce-Sese. And he testified essentially that he's driving a nice car one minute, and the next minute, he's waking up in the hospital with a tube sticking out of his chest. He had a collapsed lung, TBI, and several broken ribs. And we heard Dr. Dick Perez talk about that. And today we touched on that with Mr. Sadler on how long it takes to recover from something like that, and what are the various trainings. Almost a year later, almost a year later after the fact, he's still having issues from this, according to Mr. Sadler. This morning, we heard from an expert witness, that being Special Sergeant Berlin. He's an expert in crash investigations. I don't know if we presented the curriculum vitae to you, but you'll get it when you go into the jury room. He's investigated over 400 crashes and over 100 involving serious injuries. He's a pretty credible guy. He knows what he's talking about. And I think his testimony was quite telling. You heard him say quite a bit about the event data recorder, the EDR, the black box. And in that data, what is the most profound is the 5 seconds before the stop. The defendant actually sped up. She actually sped up. And I think it's important right now to make a point that this is not a case of deer jumping in front of a vehicle or a sudden surprise. This is a case about a clear day, a relatively broad expanse of roadway, 2 lanes going westbound, and an entire convoy of vehicles at or in the right lane. And we will talk about that in a minute. To say, during opening, counsel said the victims came out of nowhere. That defies logic. You heard Special Sergeant Berlin state, at that point, there was 1,300 feet of clear visibility. You could see in the roadway 1,300 feet in front of you. The data tells us one thing. The data tells us she wasn't paying attention. And not paying attention for that amount of time, when looking at the speed, when looking at the pressure applied to the accelerator, using the EDR, the data tells us that that operation of the vehicle like that is careless. 1, 2, 3, 4, 5. With 1,300 feet of clear visibility, vehicle driving at about 70 miles an hour, which is 100 feet per second, she should have seen them. She's responsible for seeing what's in the roadway. And she didn't, because she wasn't paying attention. Five seconds at 70 miles an hour is 700 feet. It's well over a football field in length. It defies logic to say that she was surprised. Today, you also heard from Dr. Dick Perez, who talked about Stephen Brucese's injuries. They detailed how the crash has affected his life, specifically as it related to the injuries involving Stephen. Now, I want to talk just for a second about Stephen's injuries. The law gives us this list of things that qualify as serious impairments. They're like examples. Loss of limb, loss of eye, loss or substantial impairment of bodily function, substantial visible disfigurement. But at the beginning of this, it says
Serious impairment of bodily function includes, but is not limited to, one or more of the following. And not for nothing, it does say loss of organ, measurable brain or mental impairment, and serious bone fracture. He broke 4 ribs. He had a collapsed lung, and he suffered a TBI. Today you also heard from Brendan Summer. His testimony was certainly illuminating in that he stated when he looked in the rear view mirror, he thought it was just another one of the vehicles that passed us that day. Another one of the vehicles that passed us and didn't hit us that day. Deputy Brock testified today on the Zoom. He detailed his investigation, and we parsed out the fact that the defendant knowingly pled guilty, or responsible rather, to the civil infraction of careless driving. You heard him say that him and Lieutenant Peters used the totality of the circumstances to issue the citation to the defendant, to cite the defendant when deciding who was at fault. And not for nothing, the defendant herself said she was at fault on the scene. Those are the facts. Let's talk about the law. Elements. Criminal offenses are made up of elements. Element 1, the defendant operated a motor vehicle. No question. 2, this was done on a highway. No question. 3rd, while operating, the defendant committed the moving violation of careless driving. Like we talked about at the beginning, careless driving means that, and you're going to hear an instruction on this. We just talked about this. You're going to hear an instruction on the careless driving. Well, like I read it at the beginning, and one of the jurors almost quoted it verbatim. Careless driving means to operate a vehicle in a careless or negligent manner, likely to endanger any other person or property, but without recklessness or wantonness. Now, I want to hone in on something. I want to hone in on something that Lieutenant Peters said. Lieutenant Peters with 20 years of experience. She said, when they were issuing the citation, careless, that's generous, borderline reckless. That was their assessment. That was what 2 officers of the law agreed to. And then not for nothing, as I said, the defendant herself admitted to operating carelessly and later admitted responsibility. The defense has suggested, said many different things about why people plead guilty to civil infractions or plead responsible to civil infractions. There's another reason. Because they're responsible. That's also, and probably, the most logical reason as to why people plead guilty or responsible. Your Honor, can I see the exhibit here? Thank you. November 2nd, 2019, original charge. November 5th, 2019, admit responsibility. The most logical solution is usually the correct one. When somebody commits a civil infraction and later pleads to that civil infraction, yeah, I'd suggest that she is responsible for that civil infraction. But if you don't want to take her word for it, look back at the facts. 1,300 feet of confirmed visibility in which to perform evasive action. Evasive action was not taken. Sergeant Berlin testified that in fact, from 5 seconds to 3 seconds, she sped up and applied more force to the accelerator. Sergeant Berlin testified that at 70 miles an hour, she's going at about 100 feet per second. The cold truth is she wasn't looking and she plowed into the back of these guys. That's the truth. It's not like oncoming traffic is a factor. There's an entirely another lane going westbound to use. Remember Brendan Summers say many people have passed us. So I want to address briefly some of the arguments that the defense has made in opening and that they've articulated through cross-examination. The entire defense case rests on element 4, causation. Who caused the crash? We talked at length at jury selection about the different types of crashes.
council spoke at length about gray areas. This is not a case of gray areas. This is a case of if it looks like a fish, if it smells like a fish, it is a fish. That's what this is about. The entire defense is predicated on blaming the victims of this crime. It defies logic. And not for nothing, the defendant herself said, it's my fault. It's my fault. When someone says it's my fault, that means they caused it. And that statement is supported by the great weight of the evidence, especially considering that she hit them and they did not magically appear out of nowhere, and that she had ample time to maneuver away, ample time to see them, but instead, she sped up. This was an avoidable crash. But for her carelessness, this would not have happened. And I want to make a point about the law here, because we're going to be talking, I assume, in the next 10 or so minutes a lot on causation. The law says that, but for committing the moving violation, the injury would not have occurred. That's what you have to find if you find the defendant guilty. But for the fact that the defendant, by her own admission, was adjusting her radio, searching for a song, she would not have hit them. That's a fact. You know, in civil law, and I totally confess I don't really practice civil law, but there's this thing called comparative negligence where one side judgments and things are awarded based on who's at fault or not, but who's most at fault or not. That's how things are done in the civil law. This is not the civil world. This is the criminal world that we're in. In criminal law, the test is but for. Because this, then that. But for the careless operation of the motor vehicle, she would have gone around like everybody else did that day. She would have used the appropriate passing lane. Causation's where they're hanging their hat. That must fail. That must fail because this was her fault. There were alternatives. And the fact that this was carelessness bordering recklessness, as described by the officers, certainly adds great weight to that. Now the lanes. There's been much ado about the lanes, where they were in the lane, how big the shoulder was. I don't really care. I don't care if they're running a 3-ring circus in the middle of that road. They don't have it. They have a right to not get hit. Because every driver has a responsibility to know what's in front of them. Especially when it isn't a surprise. Now, this is an incredibly serious matter. And I want to make it abundantly clear that I don't think the defendant is a bad person. Far from it. But her conduct falls within this pre-prescribed set of elements. This conduct constitutes a criminal act, and the great weight of the evidence supports that. Far beyond a reasonable doubt. And in her favor, in the defendant's favor, it doesn't matter whether she intended to do this. I'm not hiding from the word accident. I am not hiding from that. Because it doesn't matter if she intended to do it. It matters whether it happened. It matters whether her conduct happened in that order. Carelessness. If this isn't carelessness, if these circumstances don't constitute carelessness, there is no carelessness. And I'm not saying, and I can see what I can guess what you may be thinking. Come on, Bob. We've all done this. We've all looked out for a few seconds. We've all taken our eyes off the road more than we should have. But we haven't all plowed into the back of a convoy for charity on the side of the road. And all of that evidence combined goes towards the totality of the circumstances when assigning fault here, when assigning cause. When you are behind the wheel of a car, you must maintain control of that car 100% of the time. It's your responsibility. It's your responsibility to take that privilege of driving. So, I guess in summation, having heard the evidence, having heard the argument,
the great weight of the evidence pointing to full satisfaction of each element beyond a reasonable doubt, it is incumbent upon you, the jury, lady and gentlemen, to uphold your oath based on the evidence and the testimony supporting documentation and everything you've seen in the defendant's own admissions. I'd ask that you find her guilty of the known charges. Thank you.
Thank you, Mr. Steinhoff. Ms. Henderson, closing argument.
Thank you, Your Honor.
Members of the jury, I appreciate your attention also. I know it's been a lot of information delivered in a couple of days. I said to you in the beginning of this that this is a case about people who took risks on the road and who, if anybody, should be held criminally responsible for those risks taken and the consequences that have flowed from them. And the theme of the case, I think, has been borne out in the presentation of evidence here. Now, before I get into the 4 points that I'd like to make, I do want to remind you, ladies and gentlemen, that this is not a civil infraction case. Remember, we talked about those standards of proof and what's required to convict beyond a reasonable doubt. That's not a 5149 proposition as a traffic ticket would be. That's 90-10. You have to be convinced that Ms. Houghton is guilty of these offenses in order to convict her. And simple paying of a traffic ticket and an accident are not enough. The burden is much higher than that at this criminal stage of the proceedings. In order to get to a conviction, you need to be sure that Ms. Houghton's careless driving was the primary cause of the victim's injuries in this case, the primary cause of the accident, or as the jury instruction says, that her careless driving was likely to endanger person or property, and that per element 4, the injury was a direct and natural result of the careless driving. That's really the meat of the case here today. So in order to assess this, I think it makes sense to look at the causes of the accident here in a little bit of a summary fashion here. I'm going to use this whiteboard as an illustration. So we had really no dispute in this case that there was more than one cause of the accident. There was not a single person who made the accident happen with everybody else being faultless. So in this case, we've got Jamie Houghton, and then we have the fraternity. All right. One of the facts that we've heard in the record that established that Jamie Houghton contributed to the cause of this accident and the injury. Well, we know that she was driving her vehicle on a road. We know that she was traveling 69 to 72 miles an hour, 72 miles per hour in a 65 mile an hour zone. We heard testimony from Sergeant Berlin that is, basically within the realm of normal traffic, a normal level of speeding. But that's a fact that's in the record. We also have the fact that she was dividing her attention between her radio and the roadway. Dividing her attention. How do I know she was dividing her attention and not fully occupied with her radio to the exclusion of the roadway? Because we know that the roadway in that area curves uphill to a left-hand curve. Now, it's not a severe left-hand curve, but it's enough that in order to maintain the lane of travel, you would have to be paying attention to the roadway in front of you. And the evidence is that she was paying attention to the roadway. It's just that she was also paying attention to adjusting her radio, trying to find a song. There is no evidence that there was any other form of distraction within the cabin of the vehicle. No evidence that she was texting on her phone or reaching for sunglasses or doing any of the other illustrations we talked about. The only evidence, and in fact, the only thing that happened was that she was looking for a song in the radio, something that I think everybody here has done previously while driving. These are the things that she did to contribute to the accident that took place. The fraternity, on the other hand, is in a group of vehicles and a bathtub. And we know that they don't have any kind of strobe lights, no bar lights, no fire department lights, nothing you can rent from Midway or buy on Amazon. No lights on the vehicle. We've got no signs, no flags, nothing to indicate that there's a charity event going on the vehicle convoy itself. we have no trail car, meaning a car that's placed some distance back on the roadway to warn traffic coming from behind that something weird is in the road. We don't have that. We have, and these are two pieces of evidence that are not available, no evidence that the brake lights were engaged. And in fact, I would argue they probably weren't because they were headed up a hill at that point. And I am specifically referring to the brake lights of the Mercedes. And there's also no objective evidence that the hazards were on. Now, the hazards itself has been an area of contested evidence. There's not a lot of contested facts, but this one is one. And we had testimony from 3 of these members of the fraternity that they believed in some fashion that at some point the hazards were on. But the reconstructionists couldn't determine one way or the other. The police officers couldn't remember one way or the other if the hazards were on. And the fact is that the fraternity members are not reliable when it comes to the facts of this event because the ones who testified about what happened in the Mercedes in the bathtub both had traumatic brain injuries that affected their ability to remember. And I'll get back to that in a minute. But as far as the actual visual clues on the convoy itself, there was nothing to indicate that this was anything other than vehicles in traffic. There was also no way to see the pedestrian. The pedestrian was obscured, either totally or almost totally by the Mercedes. That is a fact that Sergeant Berlin testified to, that maybe if you were looking, you could have seen the top of the pedestrian's head, but otherwise there was nothing to indicate that it was anything other than a Mercedes, a vehicle in the roadway. We also have the Mercedes traveling too close. We heard from Sergeant Berlin too, that the way that this convoy was set up, that Mercedes was not providing any form of physical barrier protection to the pedestrian. It was traveling too close to provide that kind of protection. The only way in which it theoretically could have been a safety car is if it were to warn motorists coming from the back that there was something weird in the roadway. And of course, these other facts certainly tend to indicate that it wasn't providing a safety function at all. It was actually a hazard car, not a safety car. And then we have this pretty hotly contested fact. The Mercedes was in the lane. This is something that each of Mr. Bruzet and Mr. Majorana, they testified totally contrary to this. They believed that they were on the shoulder of the road and that they never moved to the lane of travel. That is not consistent with the roadway evidence that Sergeant Berlin observed. And it's actually not science to see. You can look when you observe the Exhibit 2 offered by the people. You can see the roadway evidence that this collision occurred squarely in the lane of travel. It didn't occur on the shoulder. It was in the lane of travel. And the collision was basically bumper to bumper square. You can see that from the damage that's depicted on the front end of the Cherokee. This was a completely square hit within the lane of traffic at highway speed. How on earth could this happen? The prosecution's theory is that, this is a situation where Ms. Houghton was just simply not paying attention for a period of perhaps 5 seconds. But I submit that it wasn't that at all. I didn't say in my opening that these people came out of nowhere. They didn't come out of nowhere. They were definitely there the entire time. They seemed to come out of nowhere to Ms. Houghton because she wasn't perceiving them. She didn't see them. It is totally different from a circumstance where you'd have a deer running out, or even a bathtub alone in the highway, or a 3-ring circus. That's the kind of thing that's going to catch your attention. This convoy didn't catch her attention because it was basically camouflage for the whole operation. And that's what caused the accident. It wasn't that she wasn't paying attention. It was that she didn't perceive because they didn't make themselves perceptible. The state's own expert witness confirmed that the way that this convoy was operating made an accident likely. He said that. This was a situation that was dangerous, that made an accident likely. And furthermore, we heard both from Deputy Brock and from Sergeant Berlin that this fraternity group itself violated the basic speed law by traveling 60 miles an hour under the speed limit in a 65-mile-an-hour zone, particularly without making any kind of effort to indicate that that's what they were doing to the general traveling public. If you think it's impossible that Ms. Houghton couldn't have perceived this, that it was something that she just didn't see, I think it's worth remembering what Mr. Majorana said about one of his first memories after this accident, where he woke up in the roadway. And you remember what he said about being worried about his head getting hit by traffic because he could hear the cars whizzing by him. That suggests to me that even the traffic coming up on this accident scene, where you've got clearly a Jeep in the ditch roll over, you've got a Mercedes turned around cockeyed on the highway, even at that point, without there being emergency crews and lights, the oncoming traffic was not perceiving this as the hazard that it was. And that was in a fairly unusual circumstance, not in what looked like just an ordinary traffic traveling in the road. That was point one. Causation, if you look at the primary cause of this accident, it wasn't Jamie Houghton's divided attention in driving her vehicle. It was everything that the fraternity did to make themselves look basically invisible as a risk in a roadway, a heavily trafficked roadway in this area. Now, this is not an intent crime, and by pointing out all of these things that were done, I don't need to call these fraternity kids bad people. They really aren't. I think that they had inadequate guidance about what they should be doing to be safe on the roadway, but nobody wants them to have been injured in the way that they were. It was a terrible, tragic accident. And Ms. Houghton, you can see on the video that was edited into evidence, she feels terrible. She felt terrible and she feels terrible about this. It's the sort of thing where it's traumatic for everybody involved. But is it a crime? And it's the defendant's position that this is not a criminal event. I believe, and this is point 3 of my 4, that the police viewed this situation accurately when they first came on the scene. They didn't view this as a crime scene. You'll remember that, I think, Sergeant Peters and Deputy Brock were both asked, did you take these necessary steps to get the accident evidence preserved? And both of them confirmed, we did not do that. Lieutenant Peters, as the lead officer, basically looked at rendering aid to the individuals who were injured. That was kind of priority 1. Priority 2 was assessing this for civil infraction and having Ms. Houghton ticketed. And then clean up the scene of the roadway as quickly as possible. You saw the sweeping of the debris into the side of the road. Because that was what this was. It was an accident scene. It wasn't a crime scene. And now we have a situation where in the prosecution, they're attempting to retrofit with what was essentially an accident investigation, not a crime investigation, and make it a crime. And that leaves us without a lot of evidence that we might otherwise have if this were investigated as a crime, which it wasn't. That's a forgivable thing. It's forgivable. Well, let me back up. I think that this attempt to retrofit the facts to a crime is something that the prosecution genuinely viewed as being appropriate under the circumstances as known when we first got this case. The problem is, it's the evidence that has come in and that has been available since then doesn't support the theory that the prosecution is clinging to. And I can do nothing more than point to the fact that in our opening statements, Mr. Steinhoff drew a diagram on that board that included placement of the convoy squarely on the shoulder, or perhaps straddling the fog line of the road. That is not what the evidence was. The evidence of the state's witness is that it was in the lane of travel, and that is a critical fact here. And I don't know why it came in that way, but it is important for you, ladies and gentlemen of the jury, to hold both parties to a high standard, but particularly to the prosecution, to be accurate in the presentation of facts to you. What happened here is a very regrettable accident. There is a venue for Mr. Majorana and Mr. Bruces to get made whole within the legal system. There are civil laws available, there are car insurance laws available to provide them with some compensation for their injuries. But this is a criminal case. And what happened here was not a crime. I know you've been listening very carefully. I appreciate your attention. We're asking you to consider all of the evidence and to find that the prosecution has not met its burden and return verdicts of not guilty. Thank you.
Thank you, Ms. Henderson. Any rebuttal,
Yes,
Mr.
Your Honor.
Steinhoff?
Thank you. Look over here, but not right here, what's in front of your face. That's the theory of the defense. Distractions, smoke and mirrors. Victim blaming is predictable, but unmoving given the facts of this case, given what actually happened. Nobody's arguing that she couldn't see pedestrians. We're arguing that she caused injuries to the pedestrians. Saying that the Mercedes was a hazard car, the white Mercedes was a hazard car, it defies logic. I guess tell that to Leo Mayorana, who without that car would likely not be here today. I have not hidden, the state has not hidden from any fact, and I apologize for my artistry as well at the beginning. But we have not hidden from any fact. And I maintain, it doesn't matter where they were in the lane. If the defendant's actions are what caused this accident, that's what matters. Dividing her attention, I think that's rich to say that she divided her attention, given the data, given the fact that she sped up into the accident. And it's not exactly what Berlin said either. This case is about responsibility. Blaming the victims in this case is like, it's like blaming a murder victim for walking down a dark alley. It doesn't logically follow because it's not their fault. I don't care if there was a billboard on the back of that Mercedes, she still would have hit it because she wasn't looking. The defendant's conduct was avoidable. Had she not operated her vehicle in a careless manner, Leo Mayorana would not have had to relearn how to walk. Stephen Bruchesi would not have temporarily lost an organ and broke ribs. Flashers and hazards. The great weight of the evidence suggests that the flashers were, but even then, even if they weren't, the defense still must fail. Because she is still the one who carelessly operated her vehicle and crashed into the back of the vehicle in front of her. She's got a duty. She's got a duty when operating a vehicle to maintain a safe distance from the vehicle in front of her. She didn't do that. When assigning blame, go with the one who's taken it. Because that is not only the most logical, it makes the most sense given the great weight of the evidence in front of you. 1,300 feet. 1,300 feet of this. Yeah, 3 seconds before they crash, she's still speeding. She operated carelessly. It was her fault by her own admission. She caused the injuries. Therefore, she caused the injuries. And now it's time to hold her accountable. Thank you.
Members of the jury, the evidence and arguments in this case are finished, and I will now instruct you on the law. That is, I'll explain the law that applies to this case. Remember that you have taken an oath to return a true and just verdict based only on the evidence and my instructions on the law. You must you must not let sympathy, bias, or prejudice influence your decision. You must avoid reaching conclusions that may have been unintentionally influenced by stereotypes. You must reach your own conclusions about this case individually, but you should do so only after listening to and considering the opinions of the other jurors. And they may have a different background or perspective from yours. As jurors, you must decide what the facts of this case are. This is your job and no one else's. You must think about all the evidence and then decide what each piece of evidence means and how important you think it is. You must think about all the evidence in this case, and this includes whether you believe what each of the witnesses said. What you decide about any fact in this case is final. It is my duty to instruct you on the law. You must take the law as I give it to you. If a lawyer says something different about the law, follow what I say. At various times, I've already given you some instructions about the law. You must take all my instructions together as the law you are to follow. To sum up, you should not pay attention to some instructions and ignore others. It is your job to decide what the facts of the case are, to apply the laws I give it to you, and in that way to decide this case. A person accused of a crime is presumed to be innocent. This means you must start with the presumption that the defendant is innocent. This presumption continues throughout the trial and entitles the defendant to a verdict of not guilty unless you are satisfied beyond a reasonable doubt that she is guilty. Every crime is made up of parts called elements. The prosecutor must prove each element of the crime beyond a reasonable doubt. The defendant is not required to prove her innocence or to do anything. If you find the prosecutor has not proven every element beyond a reasonable doubt, then you must find the defendant not guilty. A reasonable doubt is a fair, honest doubt, growing out of the evidence or the lack of evidence. It is not merely an imaginary or possible doubt, but is a doubt that is based on reason and common sense. A reasonable doubt is just that. A doubt that is reasonable after a careful and considered examination of all the facts and circumstances of this case. Now, every defendant has the absolute right not to testify. When you decide the case, you must not consider the fact that she did not testify. It must not affect your verdict in any way. When you discuss the case and decide on your verdict, you are only allowed to consider the evidence that has been properly admitted in this case. Therefore, it is important for you to understand what is evidence and what is not evidence. Evidence in this case includes only the sworn testimony of the witnesses and the exhibits admitted in the evidence. Many things are not evidence, and you must be careful not to consider them as such. I will now describe some of the things that are not evidence. The fact that the defendant is charged with a crime and is on trial is not evidence. The lawyer's statements are also, and their arguments are not evidence. They're only meant to help you understand the evidence and each side's legal theories. You should only accept the things the lawyers say that are supported by the evidence or by your own common sense and general knowledge. The lawyer's questions to the witnesses and your questions to the witnesses and my questions to the witnesses are also not evidence. You should consider these questions only as they give meaning to the witnesses' answers. My comments, rulings, questions, and instructions are also not evidence. It is my duty to see that the trial is conducted according to the law and to tell you the law that applies to this case. However, when I make a comment or give an instruction, I am not trying to influence your vote or express a personal opinion about the case. If you believe that I have an opinion about how you should decide this case, you must pay no attention to that opinion. You are the only judges of the facts, and you should decide this case from the evidence. At times during trial, I've excluded evidence that was offered or stricken testimony that was heard. Do not consider those things in deciding the case. Make your decision only on the evidence I let in and nothing else. Your decision should be based on all the evidence, regardless of which party produced it, and you should use your own common sense and general knowledge in weighing and judging the evidence. But you should not use any personal knowledge you may have about a place, person, or event. To repeat once more, you must decide this case based only on the evidence admitted during this trial. As I said before, it is your job to decide what the facts of this case are. You must decide which witnesses you believe and how important you think their testimony is. You do not have to accept or reject everything a witness said. You are free to believe all, none, or part of a person's testimony. In deciding which testimony you believe, you should rely on your own common sense and everyday experience. However, in deciding whether you believe a witness's testimony, you must set aside any bias, prejudice you may have based on and not be influenced by a witness's disability, gender identity, race, religion, ethnicity, sexual orientation, age, national origin, or socioeconomic status. Again, take the time you need to test what might be automatic or instinctive judgments and to reflect carefully about the evidence. Again, there is no fixed set of rules for judging whether you believe a witness, but it may help you to think about these questions. Was a witness able to see, hear clearly? How long was a witness watching or listening? Was anything else going on that might have distracted the witness? Did the witness seem to have a good memory? How did the witness look and act while testifying? Did the witness seem to be making an honest effort to tell the truth, or did the witness seem to evade the question or argue with the lawyers? Does the witness's age or maturity affect how you judge his or her testimony? Does the witness have any bias, prejudice, or personal interest in how the case is decided? Have there been any promises, threats, suggestions, or other influences that affect how the witness testified? In general, does a witness have any special reason to tell the truth or any special reason to lie? All in all, how reasonable does a witness's testimony seem when you think about all the other evidence in the case? Sometimes a testimony of different witnesses will not agree, and you must decide which testimony you accept. You should think about whether the disagreement involves something important or not, and whether you think someone is lying or simply mistaken. People see and hear things differently, and witnesses may testify honestly, but simply be wrong about what they thought they saw or remembered. It is also a good idea to think about which testimony agrees best with the other evidence in the case. However, you may conclude that a witness deliberately lied about something that is important how you decide the case. If so, you may choose not to accept anything that witness said. On the other hand, if you think the witness lied about some things but told the truth about others, you may simply accept the part you think is true and ignore the rest. You've heard testimony that a lawyer or lawyer's representative talked to one of the witnesses. There is nothing wrong with this. A lawyer or lawyer's representative may talk to a witness to find out what the witness knows about the case and what the witness's testimony will be. You've also heard testimony from witnesses who are police officers. Their testimony is to be judged by the same standards you use to evaluate the testimony of any other witness. You've heard testimony from witnesses who have given you their opinion as expert. Dr. Sean Hendren in the field of emergency medical treatment and Specialist Sergeant Daniel Verlin III in the field of traffic crash reconstruction. Experts are allowed to give opinions in court on matters they are experts on. However, you do not have to believe an expert's opinion. Instead, you should decide whether you believe it and how important you think it is. When you decide whether you believe an expert's opinion, think carefully about the reasons and the facts each gave for their opinion and whether those facts are true. You should think about the expert's qualifications and whether each of their opinions makes sense when you think about the other evidence in the case. The prosecution has introduced evidence of a statement that claims the defendant made. Before you may consider such an out-of-court statement against the defendant, you must first find that the defendant actually made the statement as given to you. If you find the defendant did make the statement, you may give the statement whatever weight you think it deserves. In deciding this, you should think about how and when the statement was made and about all the other evidence in the case. You may consider the statement in deciding the facts of the case. The defendant in this case, and I read you the elements at the beginning of the trial, and they are unchanged. The defendant is charged with 2 separate crimes of committing a moving traffic violation that caused serious impairment of a body function. To prove each of these charges, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant operated a motor vehicle. To operate means to drive or have actual physical control of the vehicle. Second, that the defendant operated the vehicle on a highway or other place open to the general public or generally accessible to motor vehicles. Third, that while operating the motor vehicle, the defendant committed a moving violation by carelessly driving. Fourth, that by committing the moving violation, the defendant caused Leo Majorana and or Stephen Brusace to suffer a serious impairment of a body function. To cause such injury to Leo Majorana or Stephen Brusace, the defendant's moving violation must have been a factual cause of the injury. That is, but for committing the moving violation, the injury would not have occurred. In addition, the injury must have been a direct and natural result of committing the moving violation. Serious impairment of a body function includes, but is not limited to, 1 or more of the followings: loss of a limb or loss of use of a limb, loss of a foot, hand, or finger or thumb, or loss of a foot, hand, finger, or thumb. Loss of use of a foot, hand, finger, or thumb. Loss of an eye or ear, or loss of use of an eye or ear. Loss or substantial impairment of a body function. Serious visible disfigurement. A comatose state that lasts for more than 3 days. Measurable brain or mental impairment, a skull fracture or other serious bone fracture, subdural hemorrhage or subdural hematoma, loss of an organ. The prosecutor need not prove that the defendant intended to cause serious impairment of a body function. To find that the defendant committed the moving violation of careless driving, you must find that she operated a vehicle in a careless or negligent manner likely to endanger any person or property, but without wantonness or recklessness. The prosecutor must also prove beyond a reasonable doubt the crime occurred on or about November 2nd, 2019 within Elger County. When you go to the jury room, you will be provided with a written copy of my final instructions. You should first choose a foreperson. The foreperson should see to it that your discussions are carried on in a businesslike way and that everyone has had a fair chance to be heard. During your deliberations, please turn off your cell phones or other communications equipment until we recess. A verdict in a criminal case must be unanimous. In order to return a verdict, it is necessary that each of you agrees on the verdict. In the jury room, you will discuss the case among yourselves, but ultimately each of you will have to make up your own mind. Any verdict must represent the individual considered judgment of each juror. It is your duty as jurors to talk to each other and to make every reasonable effort to reach an agreement. Express your opinions and the reasons for them, but keep an open mind as you listen to your fellow jurors. Rethink your opinions and do not hesitate to change your mind if you decide you were wrong. Try your best to work out your differences. However, although you should try to reach an agreement, none of you should give up your honest opinion about the case just because the other jurors disagree with you or just for the sake of reaching a verdict. In the end, your vote must be your own, and you must vote honestly and in good conscience. If you have any questions about the jury instructions before you begin deliberations, or questions that arise during deliberations, you may submit them in a writing to the bailiff. Possible penalty should not influence your decision. It is a duty of the judge to fix any penalties within the limits provided by law. And if you want to communicate with me while you're in the jury room, please have your foreperson write a note and give it to the bailiff. It is not proper for you to talk directly with the judge, the lawyers, court officers, or other people involved in the case. And as you discuss the case, you must not let anyone, including me, know how your voting stands. Therefore, until you return with a unanimous verdict, do not reveal this to anyone outside the jury room. And when you go to the jury room to deliberate, you may use and take your notes and a copy the instructions we'll give to you, and we'll send in the exhibits. Now, there is no exhibit 1, it's 2 through 8, and exhibit 3, I believe, is the digital disc, which I'll keep here. If for any reason you want to see the digital video again, we'll have to set up the equipment and bring you back out. But we'll send the other exhibits into the jury room with you. As I said, when you go into the jury room, we'll give you a written copy of the instructions you've just heard. As you discuss the case, you should think about all my instructions together as the law you are to follow. Now, I prepared a verdict form for count 1 and 2, listing the possible verdicts. Again, the defendant is charged with 2 separate counts of moving violation causing serious impairment of a body function. These are separate crimes, and the prosecutor is charging that the defendant committed both of them. You must consider each crime separately in light of all the evidence in the case. You may find the defendant guilty of all or any one or both of these crimes, or not guilty. Will counsel approach the bench at this time, please? Thank you. At this time, I'll swear in the bailiff. Do you solemnly swear or affirm that you will keep the person sworn as jurors in this trial from separating from each other, that you will not suffer any communication to be made to them orally or otherwise except by order of this court, and that you will not, before they render their verdict, communicate to any person the state of their deliberations, so help you God?
I swear.
Thank you. All rise. We'll provide the jury with the exhibits and the written instructions. Ladies and gentlemen of the jury, go to the jury room and give this matter your most serious consideration. Please be seated. The jury is in the jury room at this time out of our hearing and presence, and prior to sending the jury in to deliberate, I summoned counsel to the bench to inquire whether there were any objections to the jury instructions as presented, and both counsel indicated there were none. Is that correct, Mr. Stein?
That's accurate, Your Honor.
Ms. Henderson
Yes, Your Honor.
and Ms. Harrow, do you agree?
Yes, Your Honor.
Okay, are there any other matters that either parties would like to bring to the court at this time?
Nothing from the people, Judge.
No, Your Honor, thank you.
Okay, thank you. Court will be in recess pending the jury's verdict. Okay, can you hear me on Zoom from that location that's on our screen?
They might have plugged out.
Oh, looks like.
out, they're in the wrong spot.
All right. It should be noted that we received a note from the jury foreman, and I'll read it. Quote, "Is there a law stating that you need a strobe flashing light or signage?" Close quote. Signed foreman. I think what they're asking is that required by law. Any suggestions before I give you mine?
As much as I would like to say that we should provide an instruction saying there is no law in this situation or something like that, I think the most appropriate way forward would be to say, please decide the case based on the evidence you have.
Well, that was my suggestion. Do you
Yeah,
agree
I
with that?
The evidence and law is already supplied, yes.
Please decide this case based only on the evidence presented. Anything else to add?
That's fair, Judge.
Okay,
Okay.
that is the message we'll send back. Thank you. Court will be in recess. Thank you.
Go ahead.
All right.
Are you done with those other papers? You want me to bring them back to? You want me to bring these back to Betsy, or are you done?
Oh, you weren't joking? No, I just
No, I
started.
mean these receipted things. That's what I'm talking.
Oh, no, I just started these.
Oh,
No,
okay.
I was doing
All right.
other stuff first. Yeah, Craig's helped us file, so. Yeah, but thanks. This out of the way for now. Thanks. We should be on YouTube, yeah. Oh,
Oh,
this
you're
is,
still live.
oh, no, we shouldn't be on. I mean, hang on a second. I'll just shut this off.
We have to wait till the record is started here. Okay, the jury has announced that they've reached a verdict in this matter. All rise. We'll bring in the jury at this time. Please be seated. Ladies and gentlemen, have you reached a verdict? And if so, who shall speak for you?
Yes,
Mr.
we
Lopez, please announce your verdict.
On count one, we found the defendant guilty.
And on count two,
On count two, we found the defendant guilty.
is that all your verdict?
That's our verdict.
Okay, thank you. I'll ask the bailiff to retrieve the verdict form. A judgment of guilty will be entered, having been rendered by the jury. At this time, I'll return the exhibits to the people, and I'll be in the jury room momentarily to retrieve the rest. All rise. You may return to the jury room, and I'll be with you in a moment. This being a victim case, we'll set the matter for sentencing. Anything further at this time from either party?
I just think, I agree, Your Honor. I think setting this matter out for sentencing is appropriate. There's going to be a license sanction. That's really the only reason we're here. So that'll give the defendant some time to make some arrangements for whatever sanction that might be.
Okay, all right. Any objection by the defense? Hearing none, the court will be in recess at this time.
I assume, Your Honor, the remainder of the exhibits are in the jury room.
They are, and I'll retrieve them for you.
Very good.
Thank you. Court's in recess.